All, including you. You are joining your conference as a participant. For a menu of available commands, press *#. Your connection is now in listen-only mode.
Okay, the clerk is just testing the audio listen-in lines. We are about to begin the proceedings, testing the listen-in audio lines. Honorable Yvonne Gonzalez-Rogers presiding.
Good morning, Your Honor.
Okay, please be seated. Okay. Let's go on the record. Calling Civil Action 20-5640 Epic Games Inc. versus Apple Inc. And counsel, please state your appearances. And the mics are on at the table.
Good morning, Your Honor. Catherine Forrest for Epic.
Good morning.
Good morning, Gary Bornstein for Epic, Your Honor.
Good morning.
Good morning, Your Honor. Jonathan Evan for Epic.
Good morning, Your Honor. Justin Clark for Epic.
Good morning, Your Honor. Lauren Moskowitz for Epic. Mr. Sweeney, good morning, sir. Now I have, looks like Mr. New.
Good morning, Your Honor. Jamie for Epic.
Ms. Kloss. Good morning, Your Honor. Good morning. Mr. Rudd, good morning.
Good morning, Your Honor.
And are there are more in the back? Ms. Forrest, maybe you can introduce them as they stand.
Yes, Brendan Blake, Your Honor. Let me just also say that in the first two rows, we have our beach masters who are the people who have handled the logistics. They've been extraordinary. We have next to them Jill Greenfield over here, who has been doing a lot of the expert work. Brendan Blake doing everything. Paul Relay, our local counsel here, you may recognize from other matters. Behind him, Brent Byers, who you've seen doing examinations. Colin Hurd, who's been support for many of the witnesses, and Dan Odetek, who's also been support for many of the witnesses. And I think I've got our folks.
Way in the back. Got someone way in the back, Ms. Forrest.
Those, Your Honor, back there are two of our paralegals who are wearing masks and obscuring their ability. Hi, Benjamin Rodriguez and Awesome.
Okay. Good morning, Ms. Berenger. Come on forward. Thank you. All right. Well, welcome to the courtroom. As I said, we're on the final stretches here, so I'm being very lax with the rules, and I'm sure the chief won't get too mad at me. So, okay. On the Apple side, Mr. Doran. Good morning.
Good morning, Your Honor. We're also joined today by Kate Adams from Apple.
Good morning, okay. And Mr. Schiller. I would not forget you, sir.
Thank you.
Good morning, Your Honor. Karen Dunn for Apple.
Good morning.
Good morning, Your Honor. Dan Swanson for Apple.
Good morning.
Good morning, Your Honor. Veronica Moyer for Apple.
Good morning. And we have Mr. Spalding. And Mr. O'Keefe isn't here today just for fun. Okay, and who else do we have back there?
Good morning, Your Honor. Betty Wayne for Apple.
Okay.
And Your Honor, Heather Grenier from Apple,
Yes, good morning.
and Cindy Richmond, counsel for Apple here. She's with us, of course, and Mark Perry.
Ah, the elusive Mark Perry.
Good morning.
Good morning. I see you at the very top of the of all the filings, but I've never seen you here in person. So welcome to the courtroom. Okay, and then I believe we have the same. Let's see, Ms. Manifold, and then Dorothy Atkins from Law 360. Good morning, and Elizabeth Lopato from Birch. Good morning. So I think I have everyone. Good morning, Ms. Berenger. Good morning, Your Honor. So Vicki Berenger has been a courtroom artist for this district for a very long time, and I'm pleased that the Wall Street Journal was able to recognize some of, or at least one of the drawings. It's an art that is, if we move into something more real, then we may not have courtroom artists anymore. But I certainly have enjoyed having her in the courtroom in this trial and another trial. So thank you for being here.
Thank you, Your Honor. It's been a pleasure. And it's been a pleasure to get all of you.
Okay. So are you going to have multiple people do this argument, or Ms. Forrest?
Yes, Your Honor, for ethics, it will be Gary Bornstein.
All alone, Mr. Bornstein. They're leaving you out to dry, high or low, whatever it is.
With tremendous support before this moment.
I'm sure.
And
All right.
Your Honor, while Mr. Bornstein is lashed to the mast, on this side, I will be handling remedies. Mr. Swanson will be handling market definition and market power, and Ms. Moyer will be handling conduct and effects.
Okay, so it takes three of them, Mr. Bornstein, to...
We are used to being outnumbered in this case, Your Honor.
As I look around the courtroom, I find myself doubting that, Your Honor.
Yeah, let's just say that, as I was thinking about it, clearly either set of themes could be representing the other party. Both sides are incredibly well represented here in this case. And win or lose, you all at least get to put that on your resume. So, okay. Well, this is where I'll start. I have questions which I assure you I will ask during the course of these proceedings because I'm not capable to not ask them if I have them. But I do want to hear from you in terms of what you think. I'll give you two choices. That is, you tell me what are the two issues that are on the top of your mind that you would like time really to argue. So Mr. Bornstein will start with you. Just give me your issues. What are the top two issues you'd like to discuss?
Your Honor, market definition and remedy.
All right. And Mr. Dorn?
Your Honor, those seem like a good starting place for us as well.
Okay. So Ms. Moyer is doing conduct. Mr. Dorn, you said you're doing remedies.
Yes, Your Honor.
So it's Mr. Swanson's. All right. Well, both of you can approach the two microphones, please.
And Your Honor, we have a set of slides that contain both confidential and public information. And so with your permission, I'd pass up a copy that has the non-public information when we get to those portions. If we get to those portions, Your Honor can review them.
Okay. And I think that, do you have slides as well or not?
We do, Your Honor.
Okay.
We have.
I think probably the best thing to do then is, because I don't tend to go back and forth very much. Or I tend to go back and forth. And so I don't want to have us necessarily wait on Ms. Stone's ability to have the hot seat operator go back and forth unless it's necessary. So let's turn on the Elmo. And with the Elmo, you'll be able to just open up your binders. You can just pop that, whatever slide it is you want, on there, and everybody can see it. So, see, it works. It's old school. Do you not know old school? I mean, look, I started off in a courtroom where we had to put there was no place for the jury, the judge, and the lawyers to see the screen for the overhead, all in the same place. Someone was always blocked. So these federal courtrooms are wonderful trial places. Okay, so Ms. Stone, why don't you show them how to use that before we get started? Can you show them how to use the Elmo?
While counsel is relearning how to use an Elmo, I just wanted to note that while we're fine starting with these two issues, we do want to be sure to address conduct and effects. Thank you.
So can I just show you any reminder?
Yeah, sure.
Right, please.
Okay, did you see that, Ms. Moyer? That little thing on the front makes it smaller and larger. Little wheel. Not a little wheel like Mr. Schiller's wheel on the iPod, but you know, Mr. Schiller, I will tell you a funny story that when I tried to a jury the iPod case, it had been so long since I'd seen an iPod that the clerks brought in the physical iPod, and I tried to turn on. I said, well, where's the music? They're like, no, you have to have earbuds in. I was like, oh, okay. Totally forgot about that. Such old technology back then. Okay, so I have your two books. Well, let's get started with you, Mr. Bornstein, and let's start with the foremarket.
Sure, Your Honor. Happy to start that way in terms of our perspective on the right way to walk through the market. For the foremarket, we actually don't think there's a tremendous amount to discuss. We have testimony that we got, finally from Mr. Cook on Friday that, in fact, Apple does compete on the operating system side against Google at transcript pages 3891 to 92.
Okay. So they compete on the OS, but they also obviously they compete in mobile devices, on phones, right? You don't disagree with that, do you?
I do not disagree that they compete for the sale of phones, no. But the competition in terms of the decision that gets made by developers is what operating system am I going to write for? Am I going to write for iOS? Am I going to write for Android? It is, I think, not disputed based on the testimony of both sides' experts that these days most developers write for both. The reason they do that is that's the only way that they can reach a sufficiently broad spectrum of consumers. And that is a function of the fact that consumers will either be on iOS or on Android and rarely switch between the two.
Okay, so Mr. Swanson, is there no issue on the foremarket?
There's a big issue on the foremarket, Your Honor, because we don't regard it as a relevant market. There's no claim in this case that Apple has monopolized the smartphone OS market. There's no claim that Apple has restrained trade in a smartphone OS market. Device competition is pertinent in this case. The term duopoly has been thrown around, but in device competition, Apple faces multiple enormous companies that have worldwide scope and scale. Samsung, LG, Huawei, Oppo. If we were to restrict attention to the operating system market that Dr. Evans has defined, If you count up the operating systems, Apple has a 15 or 16% share of operating systems in the global minus China market that he defines. For every single iPhone that Apple sells in Dr. Evans' market, Android manufacturers, of which there are many, sell 5 or 6. So, but the larger point is, the issue to focus on from our standpoint is the plaintiff's claim. What are the restraints that would keep Apple?
So are you saying that I have to find a monopoly both in the foremarket and the aftermarket?
No, I'd say that.
That is, can we both agree on that? That is, there can be a foremarket and only monopolistic conduct in the aftermarket?
I'd say, as Professor Smolensky does, that it's a red herring. The question is, what keeps Apple from raising commissions in the App Store? And the issue of device competition is out there, but those are not the direct brands that we look to and that our experts define the market to be that restrain Apple from doing that in this industry. The other brands are the console stores, the Steam store, Google Play store, Samsung Galaxy store, the other stores that are on PCs and Macs. That's the issue. Device competition can be a constraint, but it is these other constraints that are the first question for the court in deciding whether or not Epic's single brand, iOS-only market is a viable market. And single brand markets are legal unicorns. And talking about operating system competition is a distraction from the key question before the court.
All right, Mr. Warmson.
Well, first, I'll note that in that answer to Your Honor's question, not a word was said about developer-side competition. We have agreement here that we're dealing with two-sided markets, and all we heard was a discussion about the consumer side and not the developer side. I think it's inarguable that developers write for Android. They don't write for Samsung, they don't write for LG, they don't write for Huawei, they don't write for Oppo and Vivo. So on the developer side, it's clear that it is a smartphone operating system market. In terms of whether it is relevant, there are extensive allegations in our complaint about operating system side competition and switching costs between iOS and Android. And we believe, for all the reasons we've laid out for the entirety of the case, that the foremarket aftermarket framework is the right way to think about this. There is some discussion in the conclusions of law from Apple that the aftermarket is kind of a brand new invention that wasn't previously disclosed, but it's discussed in Your Honor's preliminary injunction opinion. It's been in this case since the fall. And in terms of why the foremarket aftermarket framework is the right one, it's because, as with razors and razor blades or copiers and copier parts, there's a purchase of a durable good or a decision by a developer to write for a particular operating system and make that investment, followed by a subsequent market that happens down the line, where the developers and users, each of whom has made the decision to enter the foremarket, then get matched with one another through the app distribution services that Apple provides, and right now that only Apple provides. So it's not at all a distraction or a diversion to say that we need to look in the first instance at the first decision that consumers and developers make. As Your Honor said in the preliminary injunction opinion, one of the things that you do is you look at the commercial realities. And that's something that the parties have actually agreed on in the January 22 filing, is that reviewing the commercial realities of the situation, including in connection with whether you analyze a single brand market, is the right way to go about it. That's page 13 of the January 22 submission. There is agreement between the parties on that point. And here the commercial reality is that developers make a decision and they write to an operating system, typically both. And
so in a developer-side competition, though, you say developer-side competition, with whom specifically are they competing?
The developers are not competing with each other, Your Honor. The developers are making the decision to write for iOS or for Android. iOS and Android are competing with one another. The developer is the consumer, and this two-sided platform, the operating system is a two-sided platform. It has consumers and it has developers. The consumers decide between iOS or Android when they purchase their device. They are then locked in at least for 2 years or 3 years. And then when they make a new purchase for a new device, they often stay with the operating system they've chosen. That's the consumer side of this two-sided market. The other side of the two-sided market on the operating system level are the developers who are writing their apps for use on a particular operating system. So the developers are not competing with one another in this description. I'm talking about the developers or the customers of the operating system. They're one side of the two-sided market.
So are they customers or not, Mr. Swanson?
The developers are a form of customer in a two-sided transaction platform. This is a two-sided transaction market, and I'm glad Mr. Bornstein raised developers because developers develop games across all the platforms. They develop for all 3 consoles. They develop for the Windows operating system, a variety of devices that host stores on tablets and laptops and desktops that run that system. Mac OS developers develop for that. This is the game transaction, the digital game transaction market that Apple's experts have defined. This is a market defined by substitution options for both consumers and developers. And I'd be remiss if I didn't point out that and I do think it's a red herring, if we are starting out and asking the question of device substitution, then we've reached the conclusion very quickly that consoles, consumers don't switch between consoles. So on this approach to the market, every console would be monopolist. We know that this approach to the market is very litigation-driven. It's also designed to allow Epic to sue Google as a monopolist. So Apple's a monopolist, Google's a monopolist, all the consoles are monopolists. That's not an appropriate approach as the Supreme Court and the Ninth Circuit have taught. We look at substitution, we look at reasonable interchangeability, and we see game apps that are available across all of these platforms. We see consumers who own all of these devices by and large, certainly have access to them. There's been a ton of evidence on that in this case. And we see developers who develop across these platforms. And that's the nature of competition. And the key question is, can Apple raise the commission in the App Store for doing that transactions? What are the constraints? And those constraints, in the first instance, I would look at the other online stores that consumers and developers can switch to, and to take account of indirect network effects that the MX decision, the Supreme Court has taught, act as a constraint on any platform that tries to raise price. You have to look at the impact that flows from both sides, the ability of developers to move somewhere else, the ability of consumers to switch somewhere else.
Mr. Bornstein, the relevant market has to include substitutes.
I agree, Your Honor.
So if your definition is seems to not, at least on its face, include substitutes.
Right, on that one I disagree, Your Honor.
Okay, that's why I'm giving you the opportunity to explain that.
Yes. So a few things. First of all, I think it's critical that we make clear what the product is in this market. So in order to assess what the substitutes are, we have to have agreement on substitute for what. And Mr. Swanson now and Apple consistently throughout the case has been talking about game transactions. And we have, I think, a disagreement on whether that's appropriate and even what that means. The market that we have defined and that we believe to be the appropriate market is a market for app distribution. That means, at least for purposes of some of the restrictions in the case, the ones about the App Store being the exclusive way to get apps on the phone. And when I say app distribution, I mean getting an app on the phone. It's not the in-app purchase that happens down the line. It's not buying Agent Peely. It's not, buying coffee from Starbucks. It's actually getting the Fortnite app, getting the Starbucks app. There is no substitute for getting the Fortnite app or the Starbucks app or the Netflix app on your phone other than through an iOS app distribution path. And
But that's only because you defined it that way.
well, we defined it that way, Your Honor, because we think that's an appropriate definition because of...
Is there any definition that gets to the problem where the product market has actual economic substitutes?
Well, Your Honor, our view, based on the economic work that our folks have done, and as you have said, based on the commercial realities of the situation, is there is no economic substitute for getting an app on the phone. There are certainly substitutes for the App Store.
Okay, so you agree that your market definition does not include economic substitutes, but your argument is that it can't because that doesn't reflect reality.
I disagree with that articulation.
Okay, then tell me exactly what the economic substitutes are.
The economic substitutes for the App Store would be direct distribution onto an iPhone and would be an alternative App Store if it were permitted to be on the iPhone. We do not believe, and we think we have proven, that distribution of an app on an Android device or distribution of an app on a console is not an economic substitute. We agree that economic substitutes should be included, but we do not believe that those are economic substitutes because you would not see switching in sufficient numbers in terms of app distribution to constrain Apple's conduct. In other words, if Apple were to raise price for app distribution, you would not see a sufficient number of people switching over to an Android device, getting apps over on a console.
The other issue is that your formulation seems to ignore the reality that customers choose an ecosystem, right? I mean, there's a lot of evidence in this trial that in the foremarket of devices, it is Apple's business strategy to create a particular kind of ecosystem that is incredibly attractive to its purchasers, its consumers. And so if those consumers choose to enter into that ecosystem, then your economic substitutes, as you just defined them, destroy the ecosystem into which they have made a choice to enter. Just like if you buy the Xbox or you buy into, a variety of these particular walled-off gardens, you know that that's what you're buying into, and you choose to make that decision. Now, there seems to be competition that is, and that's why I said it's somewhat of a dynamic area right now because competition is good and people are trying to figure out ways, right, to access those consumer choices. But your economic substitutes destroy that consumer choice.
I'm not sure I understand the idea of destroying the consumer choice. So what I think Your Honor is saying, and let me know if I'm off base on this, is the suggestion that people are making an informed decision to say, I want to go in and buy an Apple device, and I know that if I make that choice, I'm going to be locked in to all of these downstream consequences.
So let's talk about knowledge and whether it's required under Eastman Kodak and some of the circuits that have followed.
In terms of defining a proper single brand market?
Correct.
Yeah. So my understanding certainly of NewCal, which is the leading Ninth Circuit case applying Kodak, is that there are 4 factors that the court will look at. Some of them I think are not in dispute, but I'll go, it's whether the restraint is only in the aftermarket. It's whether the aftermarket is derivative of the foremarket. It's whether the power that the monopolist has as a result of contracts that people willingly enter into. And then the last one, which is where I think Your Honor's question goes to, is the question of whether foremarket competition adequately disciplines conduct in the aftermarket. And knowledge is a piece of that. And Kodak says and NewCal says that when there are information costs and when there are switching costs, then it is harder for the foremarket competition to discipline what happens in the aftermarket. So to make that concrete here, for example, when people buy an iPhone, join the ecosystem as Your Honor described it, they don't know what the costs are going to be that they are going to incur for app distribution and in-app purchases.
Are you assuming that? We actually don't have any evidence on that topic, do we?
We do, Your Honor. We have evidence in the deposition of Mr. Q, who was asked that question, as I recall, in terms of whether people are aware or whether Apple makes efforts to inform people of this, and he said they do not. And then we also have, I think, irrefutably, the idea that the costs that people incur for app distribution and in-app purchase commissions are dwarfed by the cost that they incur in deciding to buy an iPhone, for example. And the economic evidence is pretty straightforward, that if you're thinking about a $1,000 purchase of an iPhone, then you are going to not be as interested in the 30% commission that you might pay on, a bunch of 99-cent in-app purchases or a $5 app. At some point in the future, when you don't know how many you're going to buy, you don't know what they cost, because I would say perhaps until this trial, there wasn't a lot of attention to the 30% charge that was out there and the regulatory proceedings that have been going on as well. And people also don't have just the base of information they need about the costs that they're getting into in terms of the aftermarket costs.
But isn't that but there's a difference, really, in the aftermarket costs between if you choose to buy an iPhone or an iOS phone versus choosing an Android. The costs are the same. That's why I said that don't they make an informed choice at the beginning, because they're two different ecosystems that they're moving into.
Well, two things about that, Your Honor. One, I think most people don't understand whether the costs are the same or not, because it's, as the testimony from Mr. Q shows, and I'm advised there's also trial testimony on this from Mr. Fisher and Mr. Schiller. But as the evidence shows, people are not focused on and not terribly aware of these downstream costs. If we were in a world in which there were competition, one would expect also that iOS and Android would not have exactly the same cost structure over time. There would be competition on this front, and there's not. And regardless of whether people are knowledgeable about what the numbers are, if every consumer were perfectly informed that there was a 30% charge for most in-app purchases, people aren't paying. I mean, the costs of the games, et cetera, that they're getting on the Android versus what they're getting on the iOS aren't distinctly different. That is, there isn't much movement across either platforms. Yeah. So from a consumer's perspective, the reason they don't think about it is because currently it's all the same. Right, Your Honor. It's at least largely the same, in part because there's no competition. But the one reason people don't think about it is because it's opaque. Another reason people don't think about it is because it's difficult for them to know what the costs will be down the line. In terms of the life cycle of their ownership of the device. Another reason people don't think about it is because those numbers pale in comparison to the cost of the phone. But perhaps most importantly, the issue is that if there were to be a change in those prices, if, for example, Apple were to say not 30%, but 35%, or even contrary, if Apple were benevolently to say, we're done with 30, we're going to go down to 20. There is very little reason to believe, based on the economic and factual evidence in the case, that that's going to cause switching. And what that means, because people don't pay attention to these numbers and because they're so small, because those changes won't lead to switching, it means that competition in the for market, in the selection of the operating system, doesn't discipline what they do in the aftermarket. That's the very definition. If Apple were to go to 35%, people wouldn't go buy Android.
Mr. Swanson.
None of this is in yet. None of this is in evidence. This is not the case that Epic has proven up. And there is, I think, no plausible case to be made that developers, two-sided market developers and consumers don't know and haven't known in the last 10 years that this device and this ecosystem has been in operation. Not all of these factors apply as well, as Dr. Evans admitted when I cross-examined him, to the Mac, every single one of them. And yet he said that doesn't prevent in any way the Mac from being a device that is sold in a highly competitive market. The other point I'd make here on, if you'd indulge me, is, again, the whole discussion of floor markets, we would suggest misses the point that this is not the 1990s with, heavy-duty copier machines. That's what those cases are about. They're kind of a case for one device in one era. They're in the second or third decade of the 21st century. And the evidence shows that iPhone owners, they all have PCs or Macs. They have laptops. More than half of them, under the results of Professor Hanson's survey, have consoles. They have non-iOS tablets, more than half, according to his survey. Many of these points were confirmed by Dr. Evans in cross-examination. Professor Oakley assumes the concurrent ownership of a whole boatload of devices. This is not a case where there's one device out there, and if a part is missing, you're out of luck unless you get a part for that machine. The question here is, for market definition purposes, what are the substitutes? What if Apple tries to raise the price, raise the commission in the App Store for game app transactions, and consumers and developers don't have to wait until they switch devices in order to impose constraints on Apple. Even Professor Rossi's flawed survey, which did not measure a permanent price increase, and therefore which showed a lesser response by consumers to a price increase, even that survey showed that a 5% increase in price would cause an 11% drop in sales in 30 days. That means over a tenth of the App Store's revenues would vaporize in 30 days. And that's just the first impact. That number under his confidence interval could be as high as 14% if he measured a true permanent increase in price, which is what we look at for market definition purposes, could be 20%. And the App Store suffered a 10 or 15 or 20% 30-day drop in all of its revenues. Developers would take notice. That's the import of the fact that it's a two-sided transaction platform. Developers would not sit by. That's what Dr. Evans assumed. They'd just sit there. They wouldn't do anything. That's the mistake the district court made in the Amex case. Didn't take account of the fact that there are two sides. They react to each other.
But Mr. Swanson, the 30% number has been there since the inception.
And before.
And if there was real competition, that number would move, and it hasn't.
I don't want to interrupt you before you. That's my debate topic.
So, if the relevant market here is includes developer side competition,
mm-hmm.
Why? What is so far there doesn't seem to be anything that is in the market itself that is pressuring Apple to compete. for developers?
Yeah, and I'm glad you asked that question. I think, this in my own mind, I have a complete answer to it. It goes as follows. First of all, in competitive markets, we know that when Apple chose the 30%, Black Evans said that's competitive price. And that commission rate wasn't invented by Steve Jobs. It was the commission rate that prevailed on Steam, a PC app store. It's also actually lower than the commission rate that applied for things like box sales and the distribution of software and games prior to that time. So we start out with a rate that, again, by admission of Epic's chief economic expert, is not a monopoly price, it's a competitive price. So one thing we wouldn't expect to see is that price going up. Now, Dr. Evans says Apple became a monopolist somehow, somewhere in 2010. Price didn't go up then. And I know Your Honor is not interested in hearing about the small business program, but in the interim, price has gone down. The reader rule was essentially a rule that allowed many developers to put content into their iOS apps for free. It was zero price. The multi-platform rule, which Epic benefits from, allows developers to have content purchased on other platforms. If you look at Epic, if you look at Fortnite, over 70% of Fortnite users who accessed Fortnite through iOS, at least, among other platforms, didn't spend a dime on the App Store. 80% or more of the revenues that came from folks who use Fortnite, who accessed it through iOS, perhaps along with other platforms, came on other platforms. So zero prices are very important. Quality. Apple has incredibly increased the functionality, the sensors, the software, the APIs that are available to developers. We heard testimony in this case about how the iPhone and the Android phones can hold their own now with some of the best games on consoles and PC. That is quality competition. Again, price has never gone up. In the American Express case, the whole issue was American Express had a high merchant fee model. Merchants didn't like it. Merchants wanted to create what the dissent in that case called price competition by switching people to lower cost cards. The Supreme Court, in analyzing that, said it's a two-sided market, and you have to look at both sides. You have to look at the benefits that come. And here there are a ton of benefits. There are an enormous number of zero-price transactions. Now, I know Your Honor has raised the issue of, well, who pays? And that is always an issue in two-sided transaction platforms. The nature of two-sided transaction competition is typically to create critical mass. Someone gets a better deal. Someone, sometimes pieces of both sides are benefited from that. You need to attract them to the platform. Sometimes they get zero prices. Sometimes they get a subsidy. And that's not unusual. It may not feel fair to the people. And here we've got essentially an enormously, well-resourced company that would like to pay less. And I get that. I understand the economics of that. But that doesn't mean there isn't competition in this market. It doesn't mean that Apple could raise the commission.
I haven't seen the class certification motion that's due on, I believe, June 1st.
We get a week off.
It's a week off.
After this, we get a week off, and then that comes.
But Apple's not just being sued by Mr. Sweeney and his company. They're being sued by an entire class of developers. I don't know which ones they are, right? I saw the survey, so I know you have some big supporters, you have some big detractors, and you have some people in the middle. So it's not just Mr. Sweeney. And one of the reasons why I ordered that class cert to be filed was so that I could see what they were saying. All of the developers beyond Mr. Sweeney who are in that class. So you have zero price, and I understand that. There's a lot of free out there, but these, I guess what you're saying is that qualitatively, because of the whole package, price has gone down. Maybe, I don't know. I'm expecting to hear from Mr. Bornstein that it certainly hasn't gone down in amount to justify super competitive profits. So why don't you address that first, then I'll let Mr. Bornstein weigh in.
Sure. And I would just note on that point, I guess, one other point, it's under seal, so I won't give precise numbers, but there was a average commission figure for Steam that is in the record, and that number is within and that was after Epic entered and Steam reduced its commission. And that number is within 1% of Apple's average commission. And Dr. Evans said that Steam's number is a competitive commission rate. But on the profit issue, I think Your Honor has heard that issue fully ventilated. The numbers that Epic is seizing upon are numbers that come from accounting data. They are accounting numbers that are numbers like accountants put together, better or worse. Accountants do and don't allocate costs, but this is an ecosystem case. I think if we've heard anything in this case, it is that the App Store helps incentivize people to buy iPhones, and that the investments in iPhones, in software, in device capability, and screen size are all things that attract developers into the App Store, and that bring consumers into the App Store. And all of those things are joint matters. And to allocate or not to allocate cost to the App Store, to treat it as a standalone, that is essentially a revenue number without allocating any of these enormous costs that go to the whole ecosystem. It's just not right economically. The case that everyone cites in this is the Bailey versus Allgas case, and it's highly instructive. I certainly recommend it to Your Honor to look at it. It flags these issues. It flags the issues of multiple products and joint costs, difficulty of measuring, and the like. And all of those problems exist here and now. And lastly, but I cross-examined Dr. Evans. I took him through the profit numbers from the data he had access to for the iPhone, for the iPad, and then added in those profits that he relies upon for the App Store from those accounting documents. If you add all that together, the number is in the 20s. It's not a number that is a very high number that is relied upon as proof of monopoly power on the part of Dr. Evans and Epic.
All right, Mr. Bornstein.
Well, Your Honor, there was a lot there. I have tried to keep notes. I'll start, if I can, back on the subject of whether or not Apple feels competition to lower or other its prices or to change its terms in ways that are favorable to developers. And I think the record is clear that there is nothing. There's literally nothing except one document I'll talk about where there are people at Apple saying to one another, gee, we need to do something in order to stay competitive on price. The one document that's an exception is Mr. Schiller's comment in 2011 that maybe we're not going to be able to keep the 70-30 for a long time, and we'll have to bring it down because there will be competition. Obviously, that never happened. In terms of...
You can't ignore, right, the quality issue. I mean, Mr. Sweeney admitted himself that back in 2011, 2012, the nature of the games that he was creating could not have been played on the iPhone. There is an enormous amount of innovation on the iPhone that is in fact allowing these games to be played, and which game developers are benefiting from.
There is stipulated a tremendous amount of innovation on the iPhone. There is not innovation on the App Store. But this is the case not about innovation on the device or even innovation on the operating system. This is the case about a monopoly on the distribution of the apps. We saw the developer surveys, and we've got more in the record that we can point the court to that have been entered in the record already, where there is consistent dissatisfaction and no progress by Apple to fix the problem because they don't feel competition on the developer side to do so. Sure, they innovate on the iPhone because they want to sell more iPhones. They want consumers to buy them, and they make them better. There's no question about that.
When they make them better, they increase the size of the platform, and the developers benefit from that.
True, Your Honor. Both sides, consumers and developers, benefit from the innovation in the device and the innovation in the operating system. But we're not complaining about the device or the operating system. The issue here is the monopoly that they have on the distribution of apps onto that platform. There is no path onto that platform other than the one that they control. That has led to decreased innovation and higher prices. And that's why you see the profits that we were talking about.
So why doesn't the reader rule, that's one thing, why doesn't that impact your analysis?
I'm glad that Mr. Swanson mentioned the reader rule, Your Honor. The reader rule is not a price decrease at all. The reader rule is a way of increasing friction that doesn't need to exist. There's no reduction in price associated with the reader rule. What the reader rule is it says, okay, you can go buy something somewhere else, and then you can watch it or read it on our device. That's not a reduction in price. We're talking about, for example, a situation where Amazon Kindle had books that you could buy on the iPhone. You could purchase them on the iPhone without having to pay anything because it was before IAP even existed. And the technology shows that they could make those purchases on the iPhone before IAP.
And before 2010, so I don't know why. There was a lot of focus on that, but even your own experts say that there was no monopolistic conduct prior to the end of 2010. So what?
Well, it's an example, Your Honor, of how they have changed the pricing over time. People have been brought into the ecosystem, and then there have been changes. To fill out the point about the reader rule, which actually goes past 2010, what happened is for a period of time, as the documents in the record show, there was an exception that was held out for Amazon to be able to encourage people to go buy their, where there was a link that was in the app so that people could click the link and go buy elsewhere. And as we all know, they eventually got rid of that too, and now you can't even have the link to go buy elsewhere. And in terms of what caused the reader rule to exist even, there's no evidence that it was a result of competition. You take a look at Steam, for example. Yes, there was a price reduction on Steam because competition came in. Did that cause Apple to lower its price? No, Mr. Cook didn't even know who Steam was, much less feel like he had to lower his price because of competition. There's no evidence whatsoever, as Professor Schmallenby conceded, of any instance in which Apple felt pressure to lower its price or change its terms because of something that happened on the game console or something that happened on PCs. So while they say there's this cross-platform market and they feel competition from these places, there's no evidence that that has happened at all. I'll give two examples just so I can see if I can use my Elmo skills here. So there was discussion, even if we're thinking about a market in which we're looking at the actual purchases that get made in-game rather than just the distribution of the app itself. Here are the facts from Dr. Cragg about the availability of the top iOS games on other platforms. They're all on Android, right? That's clear because people who are developers need to be on both devices in order to get to people. There are very, very few on the consoles, on the Switch, and even on the personal computer. Your Honor will remember that Dr. Hitt had a very different analysis that he's now withdrawn because it was shown to be incorrect. There was an effort to resuscitate it through Mr. Schmid, and I think that fizzled too. And as for the question, and so this just shows people can't substitute for their games, even if we looked at games, in the way that Apple claims. We obviously think we ought to be looking at more than games. We ought to be looking at Uber and Starbucks and the banking app and all other apps that are subject to these restrictions. But if we're talking about a litigation-driven market, here is a clear indication, Your Honor, which of the two parties has the litigation-driven market.
What about a market that was mobile gaming as opposed to gaming generally? Why not that market, given that you're not here on behalf of a class of developers, just on behalf of Fortnite?
Well, if the question is, could the market be defined as games that are on iOS?
I'm talking about games on mobile devices, Switch, iOS, Android.
Well, Your Honor, we would exclude Switch from the concept of mobile devices because there is no cellular connection, and because people tend not to carry them around with them all the time. And there is a very different category of games that are available on Switch, as the last slide showed, as compared to iOS and Android devices. There's very, very few games that are on iOS and also on Switch.
You would put iPads in the same category as Switch?
The iPads, I'm not sure where the iPads go on.
Well, they don't all have cellular connections.
They don't all have cellular connections, but they do tend to have the same set of games that are on iOS, rather than the set of games that are on Switch. The category of apps on the iPad is more similar.
Android, iOS, mobile gaming.
So that market, we think, Your Honor, makes a lot more sense than a market that is sweeping in all of the other non-mobile devices for all the reasons that Dr. Evans talked about. The mobile devices occupy a very different place in the way that consumers use them. They're able to use them while they're out and about. They're able to take advantage of the capabilities that the smartphones have in a way that the other devices don't have. If we had a market that was limited to games on iOS and Android, we would still have a market in which, although not monopoly power, Apple still has very substantial market power, even in that two-brand market, which Dr. Evans walks through in his report. He does it, admittedly, in the context of all apps rather than just games on the two platforms. Given Brown Shoe and NewCal, one could even think of iOS as a sub-market in the broader mobile gaming market. So while, as Your Honor knows, that is not the market that we have advocated for, we certainly think that that makes a lot more sense than the broader market that Apple has advocated for here, given the difference in the platforms.
What about that market definition?
Well, certainly those platforms and the online game stores that are available on them are included in the market that our experts define, but we think the market is broader than that. And we looked at the evidence, Your Honor, and I think the evidence sustains that view. Obviously, Professor Hitt gave the panoramic view of the evidence on that point, but just touching on a couple of things. And actually, Dr. Craig's own evidence, you will recall, we went through the chart that showed what happened after Fortnite debuted on the Switch, after the Switch was introduced. And there was the first month when there was a brand new season of Fortnite, so that one jumped up. But when you looked at the succeeding months, what you saw was Switch, which we do think is a mobile device, took market share. It took market share from all the other platforms, consoles, PC. And when you look at, again, Fortnite players, they play on all of these platforms. Again, going back to the study that Professor Hitt had done, the great bulk of them that have access to Fortnite through iOS spend on the other platforms, PCs, consoles. We also had Professor Hitt look at what happened when iOS users download an app that's used for consoles, an app that allows you to control your console, for example, from iOS. Those.
Well, how would it affect? I mean, I understand that you're making factual distinctions, but if I decided that the relevant market was mobile gaming, how does that impact your analysis?
Well, it makes me very sad, but
what's that?
It's not relevant. I understand, but
it would be very sad. That's interesting.
I noticed you're writing that down.
No, I just was looking at the real time.
Okay.
Yeah.
Then the monopoly claims go away, and obviously the other remaining claims would have to be analyzed with respect to a rather minimal degree of market power in that context. Again, we think that the other platforms, the other devices, which us and iPhone owners have at the ready in case Apple were to try to raise commissions, would come into play and would stop that. And again,
that's a good segue, Mr. Swanson. How does the UCL claims then get impacted? If I decide that the relevant market is gaming, there's not a monopoly, but there are other factors showing anti-competitive conduct. There is a UCL claim, and under the UCL claim, there are three different prongs which are available to the court. One of which must be tied, the unlawful prong must be tied to existing law. I suspect that I have to say I didn't get through all 1,000 pages of filings over the weekend, but I've done UCLs long enough to know the unlawful wouldn't necessarily be available if there isn't a Section 1 or Section 2 claim. But the unfair prong seems to me to be an available mechanism for addressing anti-competitive conduct to the extent it exists. Would you agree with that, Mr. Bornstein?
I would, Your Honor. And as the court knows, we have made that claim. There is a dispute between the parties as to which of those prongs Epic is able to take advantage of, given the distinction between competitor and consumer. It is our position, and we think we've shown that we fit under both categories. We are a competitor as a distributor, and we are a consumer of their app distribution services and their payment solution services in the two-sided market. And when you then get to the unfair prong, as the court knows, there are different prongs of the unfair prong. Right? There is the tethering test, which is very similar to the unlawful prong, although I would note that the California courts have been both clear and vague. Clear in saying that it's a broader and deeper statute than just the Sherman Act. Vague in not being precise about exactly how broader and how deeper and in what ways. But in addition to the tethering test, there is the balancing test, which under CELTEC does apply and requires the court to look at the harms that are caused and to consider them in context with the benefits that are intended to be achieved. It's well, as the name says, it's a balancing test. You look at the injury caused by the conduct and balanced against the utility of that conduct and the gravity of the harm that's alleged. And so we certainly do think that is an important part of the analysis that the court will ultimately need to go through with. Should ultimately go through if it doesn't get through the Sherman Act.
There is some California law that suggests that incipient antitrust violations and conduct that violates the spirit of the antitrust laws does in fact constitute a UCL violation.
Absolutely, Your Honor.
Mr. Swanson, on the UCL.
Yes, I mean, again, Epic is professing UCL as a prospective competitor, certainly in R, a defined relevant market. They're an existing competitor with the Epic Game Store. I think they are tied to the CellTech standard. I think that we need to show an antitrust violation, or at least a near antitrust violation. I think, Your Honor, in the PNY Technologies versus SanDisk case, dealt with a case where you dismissed a UCL claim where the plaintiffs' theories weren't materially different from the federal antitrust claims. That has been the focus of this trial, and we think that the federal antitrust claims, if dismissed as they should be, would not sustain a CellTech theory on the UCL.
They're separate prongs, and the analysis is separate. In the SanDisk case that you cited, if memory serves, there was a parallel state court action in California that was addressing those state court allegations. I was dealing with the federal antitrust allegations. I was not dealing with the state antitrust allegations. And I believe, although I can go back and check, that I dismissed to allow the state court to address it on its own, given that's what the state court was already doing. So I deferred to the state court with respect to the state case.
But I come back to CellTech on the competitive claim. And then on the balancing claim, Apple has advanced a variety of legitimate business justifications for its conduct. Apple has pointed to what we consider to be enormous pro-competitive effects.
I understand that, and I just want to make sure that I understand clearly your legal argument. CellTech, I thought, expressly stated that a violation of antitrust law was not required for a finding of a UCL violation.
It's a tethering to an antitrust violation. Agreed.
Right, and that's why if there's some incipient antitrust violation, but not necessarily a technical or a violation, that might be enough.
Although, again, for injunctive relief, some true threatened harm would be required. Incipiency, certainly under the federal antitrust statutes, which have incipiency requirements like Section 7 of the Clayton Act, like the Robinson-Patman Act, when the Supreme Court has dealt with those claims, it has required proof for those who are actually seeking relief.
This isn't federal law. This is California law.
It is, but they're incipiency statutes. So I guess I'm just arguing by analogy to federal incipiency antitrust statutes. When the rubber hits the road, the plaintiff still needs, if they're going to get some relief, to show something that's a concrete threat. I'd also add, Your Honor, there's a jurisdictional issue. This is conduct that is affecting far more than California consumers, California businesses.
So I could, and we'll get to the remedy portion. I'll let Mr. Dorn argue that. But so I order it in California and nowhere else, and all Californians, you can take advantage and section us off or something.
It certainly raises remedial issues, and I'm happy to punt that to Mr. Dorn, but I would be remiss if I didn't mention them.
All right. Okay. Let's talk about something slightly different. The least or less restrictive alternative. What role, if any, does that play in a Section 2 analysis? Mr. Bornstein.
So, Your Honor, the law on Section 2 analysis for less restrictive alternatives, I'd say, has two pieces that need to be addressed. Number one, there is the Ninth Circuit image tech case, which is part of the whole Kodak line, that says there is no least restrictive alternative test in Section 2. The Ninth Circuit has moved since then. In 2008, in Cascade Health, in a Section 2 case, the Ninth Circuit referred to the pro-competitive benefit needing to be achieved in not an unnecessarily restrictive way, and has certainly not let go of the concept of less restrictive. The other piece of this that I think is important, however, is I think that Apple, by focusing on the specific word less restrictive alternative, is avoiding the more important or kind of larger issue, which is whether the court in a Section 2 case does any kind of balancing or assessment of the pro-competitive justification and how it's achieved. In the Qualcomm case, very recent, obviously, from the Ninth Circuit, is very clear, citing Microsoft and adopting the reasoning there, that there is a balancing that is supposed to be done. And so whether you call it less restrictive alternative or whether you call it balancing, it is the case that in the Ninth Circuit, as elsewhere, but certainly in the Ninth Circuit, you don't just look and see, has the defendant articulated some modicum of pro-competitive benefit and then put your pencil down. That's not the law. Otherwise, Section 2 would be pretty close to a dead letter. In fact, the court does have to do an analysis that assesses that pro-competitive justification and how it is achieved, and think about that in the context of all of the harm that is inflicted by it. And that's what Qualcomm, citing and relying on Microsoft. In the context, I should point out, of a high technology case involving software. That is what those cases teach.
So I agree that image tech states that we believe is the rule, that there is no less restrictive alternative test under Section 2. I think the Supreme Court has essentially echoed that position in the Trinco case. Supreme Court, the conclusion of that case said Section 2 does not give a court a commission to restructure markets if it is believed that the markets could be made more competitive. In the Qualcomm case, the Ninth Circuit touched on Qualcomm's justifications for its conduct in a way that one might look at as evaluating alternatives. But the Ninth Circuit said, we don't need to reach that. We only need to touch on this because the primary burden, the key burden, the gating burden of the plaintiff is to show a substantial anti-competitive effect. That is the first step. Now, if there are amazingly less anti-competitive or more competitive alternatives, presumably that would jump out in the first stage of the Section 2 analysis. But there is no less restrictive alternative test in the Section 2, and I certainly stand on image tech on that point.
Any response?
Well, Your Honor, starting with Qualcomm, the reason the court in Qualcomm didn't have to dive into the details of whether or not there was a less restrictive alternative is because the FTC failed on prong one.
Because the FTC, I didn't hear you.
I apologize. I swallowed that sentence. The FTC failed on prong one. It never showed the substantial anti-competitive effect that it would need to show in order for the court to move to the next step of the rule of reason analysis. And so there was no need ultimately to get all the way down the line. But in stating the rule, the court was quite clear that there is a balancing test or a balancing step to the Section 2 rule of reason analysis.
So are you equating then balancing with least or less restrictive alternative?
Your Honor, I think they're largely the same. I know the courts have talked about them as different things, but I think in practice, if what you're doing is you're looking to assess whether the restraint at issue is on balance a problem, one of the things that clearly you would do in making that judgment is think about what the alternatives are to achieving the pro-competitive benefit that the defendant claims is the basis for the challenge restraint. So although, analytically there are cases that describe each of them, I think ultimately the inquiries largely collapse. And the particular label that you place on it, I think, is less critical than the substantive analysis that gets done in that final step of the rule of reason analysis under Section 2.
Anything further on this?
I mean, I think one has to look long and hard to find a Section 2 case that goes beyond the first two prongs, anti-competitive effect and legitimate business justification. The notion of a third balancing prong comes from the Microsoft case, and yet in the Microsoft case, every time Microsoft failed to offer a legitimate business justification, it lost, and every time it offered a legitimate business justification, it won. There was no balancing. Balancing is it's a topic for antitrust scholars who all recognize there's no guidance about how to do it. And courts, I think, do collapse it all into the first two prongs. If there even is, in reality, a third prong. And also this is somewhat theoretical because Dr. Evans said, for example, he wasn't testifying to less restrictive alternatives.
Yeah. Again, that's a good example of how we're getting caught up in terminology. Dr. Evans absolutely has in his testimony the idea of balancing, and he did testify as to the alternative way, for example, that Your Honor described the market in terms of putting iOS and Android together. That's in his testimony at paragraph 119, beginning there. And whether one gets caught up in the terminology of less restrictive alternative or not, the substance of the balancing is very much in the record. And although I heard Mr. Swanson talk about the outcome in Microsoft, I did not hear a dispute as to the rule of Microsoft, which was then reiterated by the Ninth Circuit last year in the Qualcomm case. That is the law. Whether the courts have yet to get to that step because of where things stand in the particular cases they've analyzed on the preceding steps is a matter that one can look through on a case-by-case basis. But in terms of what the rule is, I don't think there's any dispute that the Ninth Circuit definitively and authoritatively articulated the rule just last year.
So Qualcomm says that if a monopolist asserts a pro-competitive justification, then the burden shifts back to the plaintiff to rebut the claim. If the plaintiff cannot rebut the monopolist's pro-competitive justification, then the plaintiff must demonstrate that the anti-competitive harm of the conduct outweighs the pro-competitive benefit. And it seems to me to be a balancing test.
That is what it says. That's what Microsoft says. The courts, as I say, to find an actual Supreme Court case that says that, or a Ninth Circuit or a DC Circuit case that actually proceeds past finding a legitimate justification to balancing is an exercise I've tried and I've come up short.
Well, what it doesn't give is a lot of guidance about what's in balancing. It doesn't say that it doesn't say that I am allowed to not balance. That is, I'm required to do the balancing, it seems to me, without a lot of guidance.
And there's a burden of proof there as well, which comes into play.
But you would admit I have to do it under the law.
I would admit that the case law says that if you get to that point, if you get beyond, if you certainly have to get beyond the first prong to get there.
I agree. But if I do, then you concede I have to. That is, in fact, the test.
I don't think that is actually the law from the Supreme Court. I don't think the Supreme Court has opined on that. I don't think the court would actually embrace that view. The Supreme Court has a case now in front of it under Section 1 on less restrictive alternatives. It doesn't.
Which case is that?
It is. It's the NCAA case, I think. It's not the O'Bannon case, but one of the follow-on cases. Having a senior moment at the moment.
Are we going to?
I will. help Mr. Swanson with NCAA called versus Alston.
We're going to get a ruling on that this summer.
We should get a ruling on that this summer. I would say I don't think it's going to affect Your Honor's consideration very much, given the substance of the case. And as Mr. Swanson accurately said, it is under Section 1, and so it doesn't address the specific issue we're discussing right now.
Okay. All right. Well, don't call us the Wild West for nothing. Okay. Let's see. I gave an opening option for Mr. Bornstein. Do you want to move to something else in particular, Mr. Swanson?
I think probably my colleagues might step up and relieve me.
Okay, hold on. Are we done on relevant market?
I had a few things that I would hope to be able to respond to that Mr. Swanson had said, if that's okay with the court.
Sure, so as long as it's efficient.
I will do my very, very best.
I'll interrupt you if not.
I expect no less. One thing is just to address this concept of limiting the relevant market to games at all, which, as the court knows, we've had a lot of discussion about. I'll make just 2 points on that. One is Epic, of course, is not just a games company. It has other apps.
I understand that argument.
Yeah. And then the other is, as we've said at some length, and we briefed, in deciding what the relevant market is, one does not look at the plaintiff. And I'll see if I can do my Elmo work again. This is what Your Honor said, and we think accurately in the preliminary injunction opinion, that antitrust law doesn't focus on individual consumers or producers like Epic. It looks at market aggregates. And what the court needs to do in assessing what the relevant market is to see whether there's sufficient switching that could occur in order to discipline the conduct that's at issue. In our case, the conduct at issue, of course, applies to all apps. And so one needs to look at whether there could be sufficient switching and identify all of the consumers and producers that are affected. What one does is look at the producers to see, as the court said in retail, what the alternatives are. And here, limiting that to games is cutting off part of the market that is affected by the conduct solely on the basis of who the plaintiff is. Your Honor has a class, as you said. It would be passing strange to define a different market in the class action or in an action brought by a government regulator, such as the EU, which has defined an app distribution market not limited to games.
Well, it's also based upon the evidence that's in the record. And I am limited in that regard as well.
Your Honor, we have testimony from Mr. Simon of Down Dog, who has a yoga app. We have evidence in the record from
the question is whether I'm going to find sufficient one example or a handful of examples to somehow justify the conduct with respect to hundreds of thousands, not thousands, right? So it's an assessment of evidence.
Your Honor, I obviously, as in all of this, you're going to have to assess the evidence. The guidance, as you said, in antitrust law is not always clear, and focusing on the facts, as Qualcomm teaches, is the right thing to do. But here, in addition to Epic, we do have specific testimony from other app makers, Mr. Ong from Match Group, Mr. Simon from Down Dog, and we have the aggregate evidence from Apple, which applies not just to games, but to all developers. So that survey, for example, that we looked at, and there are multiple.
And I'll be spending quite a bit of time with that survey and what it really means and what it doesn't mean. I don't know, because you all showed me one slide, and now I have to go see what that means. Maybe I just don't know what it means because I haven't had a chance to really investigate.
Of course, Your Honor. And if I could, I'd actually like to give Your Honor citations to some other surveys that are in the record. If that would be helpful.
I'm sure it's in your 500 pages.
Very good.
So a response on that topic, anything?
Specifically on that topic, Epic's decided to define an all iOS transaction market. So they've got a single brand and they say all of the app transactions under that brand belong in the market. Now, the rule of substitution, and yet Dr. Evans said, no, they're not substitutes. Game app transactions are definitely not substitutes for non-game app transactions. Now, the only escape hatch from that would be a cluster market. And Your Honor raised that in the PI motion, PI order decision, and put that to the parties. Professor LaFontaine addressed that in her expert report, said that Epic's market definition is not a cluster market. I asked Dr. Evans on cross, is it a cluster market? He said no. Your Honor probed Dr. Evans and asked the same question, better question, again, more probing question, and he said no, it's not a cluster market. So Epic has decided to lump non-substitutes together without any basis under the law. If they had wanted to define a game app transaction market and other markets that are served on the platform, they could have done so. Your Honor heard Mr. Sweeney, in fact, testify he wasn't familiar with the competitive conditions for other apps, other app developers. I think the recent expansion of the scope of the Epic Game Store falls under the category, if anything, of litigation-driven developments, but be that as it may, it is Epic's burden, and it's their burden to define a market. If they fail to define a proper market, they lose. That is very clear in Ninth Circuit authority, and they have defined the wrong market.
And Your Honor, thank you. It's not a cluster market, and we haven't defined a cluster market because the cluster market would be a mistake here. As Professor LaFontaine herself explained when she talked about the Staples matter that she worked on at the FTC, where a cluster market was at issue, that was a place where the defendant was selling multiple things. It had ink, it had toner, it had literal staples, it had Scotch tape, it was selling paper. And the question was whether you put all of those things together in a market or not. Here, we're not dealing with that at all. We're dealing with the App Store, which sells transactions. Professor LaFontaine said that as well.
Also has free apps, which you all consistently ignore.
Absolutely not, Your Honor. The free apps are absolutely part of this market. They too are stuck with the App Store being the only way to get on the store. They are just as stuck as the rest of us.
Complaints about from entities. Again, I'll go back and look at the survey, but I haven't heard any complaints from entities for whom they aren't benefiting. Right? It's not part of their model to make money from in-app purchases.
That is true. But in terms of app distribution, Your Honor, there are tons of complaints in these surveys from people who are not selling in-app purchases. People want search and discovery features that are better. They don't want to have to pay in order to get their app listed first when you type in the name of their app. They don't want to be stuck on page 25 because there are all of these people that pop up earlier when you do search.
How many apps are there, Mr. Bornstein?
There are 1.8 million.
Right, 1.8 million divided into 27 categories. What's the math? Do you know?
Well, it's not even, obviously, so there are lumpy categories.
And so I hear you make that argument, and yet I think as a practical matter, if you have 100,000 apps in a category, and people are complaining that they're not at the top of the list.
So when someone types in, for example, down dog, I'll just use them because they came and testified, and what they get as the first 5 or 6 things are not their app. Even if someone types in the word down dog,
right, and
they get 5 other apps that are not their app that precede them, that's a problem with the search feature.
That is an ad search feature. That is what happens when you go on Google. It says ad. You can go down. I mean, by the way, and I hope this is good advertising for down dogs, given that they came in here. When I typed them into mine, this weekend came right up. That was the first thing. So maybe people don't want to compete with them anymore. I don't know. But it's not unreasonable when you have 100,000 apps in a category to expect that there's going to be advertising. It happens. Really want to travel. Went to Travelocity this weekend. Right. The first things that come up are the paid apps. This isn't something that's not happening in the digital world.
One of the things that a transaction platform like the App Store is supposed to provide are quality search and discovery features, quality marketing and promotion features. When you look at the surveys, Your Honor, you see complaint after complaint on just those issues. This is what they should be providing, and these are the things that are suffering as a result of the anti-competitive conduct.
No, I'll look. Anything else on this?
Just to add, I mean, that's exactly right. There are lots of apps on the App Store. Developers are like everyone else. Their competition isn't always welcome. You ask Uber drivers, the more Uber drivers are in the neighborhood, the more unhappy Uber drivers are, but the happier consumers are. And at the end of the day, the better off Uber drivers are because that draws people to the platform. And as Mr. Simon with Downbod found, he made an enormous amount of money on iOS over the last year while he's complaining. And yes, there are some complaints about search. Ms. Moyer will talk a bit more about that. The same surveys show developers are overwhelmingly happy with the App Store.
Mr. Bornstein, you wanted to make 2 points.
Well, I think what's useful for me, from my perspective, is just to finish the analytical point on clustering.
Okay.
The reason clustering doesn't apply here is, unlike in Staples, where they were selling multiple things, the App Store is selling one thing. It's selling transactions. It's selling these services that facilitate developers and users coming together. And it sells the same thing to the Starbucks app. It sells the same thing to the developer of the Waze app. It sells the same thing to Epic and other developers of games and other apps. And because it is the very same product that is at issue here, there's no clustering of ink and toner and staples and Scotch tape need to be put together. Or in the hospital example that Professor LaFontaine gave, it's not knee surgery and an intensive care for a car accident. It's the same thing, so there's nothing to cluster together. Everybody's buying the same service. The customers themselves are heterogeneous, to use the economic term. They do different things with what they buy. But that's just like in Amex, where a restaurant gets credit card services and the clothing boutique gets credit card services, and the hardware store gets credit card services. They're all buying the same thing, even though they then go on in their business and don't compete with one another. Same thing here. The apps or the developers all buy the same thing, and they don't necessarily go on downstream in their business and compete with one another. So there's nothing to cluster together because there's just one thing.
You wanted to make one other point before Mr. Swanson sits down?
I guess the last point to make, Your Honor, is just to go back to the character of the competition here and on the 30%. Really what we've heard again and again is that we don't think people should have to make these choices. We don't think people should have to choose among stores. And in terms of the price that has been charged, there's no evidence that people at Apple have felt the need to lower it as a result of developer competition. And we think that's very telling about the state of where they are. And I haven't gone into the profit issue. We have a number of slides which I won't walk the court through, but I would commend you to Mr. Barnes' report, where, contrary to what we heard from Mr. Cook about whether those costs were fully burdened, Mr. Barnes very carefully ties out the numbers to the public filings. And I realize Mr. Barnes didn't work at Apple, as has been pointed out multiple times, but the numbers are the numbers, and the numbers don't lie.
Yeah, but your own client said that that's not a logical way to think about profitability when that's not your business model.
Not a logical way to think about how they run their business. And I take Mr. Cook at his word that they don't actually do regular profit and loss statements of this type. But when you're looking to see what the economic profitability is, and you have people at Apple actually sit down and do this work, they don't do that at Epic. Mr. Sweeney spoke about Epic. There's no evidence that anybody at Epic has ever made that wave chart that Your Honor saw of the R&D kind of landing down in the rest of services bucket. And I won't say the numbers, but Your Honor may remember graphically what that looks like. That work got done. It got done multiple times, despite our being told it was a one-off presentation. And it was used There were questions that were followed up about it. It clearly got attention at the highest levels of Apple. It was not a waste of time. It was done for a reason, and it was done again. So to point to how Mr. Sweeney runs his business without any factual evidence that anything like that happened at Epic is a false equivalence, where you have people at Apple who have done this again and again and again.
Any comment on that?
2 comments. One on the claim that all app transactions in the App Store are substitutes. That's not what Dr. Evans said at page 1641 of the transcript. He said AMAP transactions in the App Store are not substitutes for all the other transactions. With respect to the profit issue, I'd boil it down to this. Those numbers mean what Epic says they do. Then what Mr. Cook should do is sell the device business and double down on the App Store. It doesn't make any sense.
Okay. Let's then move to conduct. Thank you, Mr. Swanson.
Thank you, Your Honor.
And I'm going to ask the question the economist kept asking the court, which is whether I can have a drink of water for a moment. Thank you, Your
Honor. I'll let Ms. Moyer start since you have the floor for a while.
Thank you, Your Honor. Good morning.
Good morning.
I would like to start by directly addressing a couple of the factual points that came up in Mr. Bornstein's presentation so far. Starting with the question of developer surveys and whether developers are satisfied or not. On Friday, Mr. Bornstein provided the court with a citation to a particular page from a survey deck. And this was a survey done in 2017. The exhibit number was BX3922, and Mr. Bornstein referred the court to page .072. Your Honor, that slide reports the results in response to a question regarding satisfaction with discovery of my apps. And Your Honor, what I have for the court now is the page from that same survey that reports on App Store developer satisfaction overall. This is page BX3922.063. I actually have a copy of the page for Your Honor. I will try to put it on the normal.
If I can do it, you can do it.
You may want a copy for yourself because the numbers are a little hard to make out. But what this shows is that in this 2017 survey, 64% of developers reported being satisfied, and only 22% reported some level of dissatisfaction. And Your Honor, that's a sustained level of satisfaction with the App Store. If we look at the same survey results from 2018, and I have that slide also for the court. This is exhibit BX3513, and I'm referring specifically to page .015. And you will see, Your Honor, here that in 2018, 65% of developers reported being satisfied with the App Store, while only 19% reported dissatisfaction. So, Your Honor, the evidence on the level of developer support we submit, once the court actually combs through the evidence, you will see that developers are highly satisfied. And there's also significant evidence in the record that Apple has listened to and responded to developer feedback. To refer to just one example, Early survey reports suggested that there was dissatisfaction with the time it took to complete the app review process from developers' point of view. And you heard Mr. Cosmica talk about the major investment that was made to improve that process so that Apple now completes review of 96% of app submissions within 24 hours. You also heard Mr. Cosmica explain and Mr. Schiller explain the significant investments that Apple has made in improving the quality of the App Store, that there was a 2017 overhaul, 2016-2017 overhaul, where many improvements were made, that categories have been created to enhance discoverability. The record is replete with examples of investments and responsiveness to developer feedback, and also with developer satisfaction with that. The other issue that I thought I should address at the outset is this assertion that there is no evidence that Apple has made price changes in response to competitive pressure. And Your Honor, that is not true. Mr. Schiller testified in the trial testimony starting at 2808, line 4, that Apple introduced the multi-platform rule in response to game developers. And the quote was, to continue to be competitive with platforms that allow cross-wallet. This move, this adoption of the multi-platform rule allowed developers to sell content that could be used on the App Store, in their apps on the App Store, without paying any commission to Apple. So rather than the 30% that would have been paid if IAP was used and if the content was purchased on the platform, developers were able to sell that content at a price return to Apple of 0. That's a remarkable price decrease, and there is testimony in the record from Mr. Schiller that that decrease was made in response to competition. The record also shows several examples of price reductions by Apple since the introduction of the App Store. I just have one chart that I can walk through quickly on that.
And then after that, John, I'll let you respond, Mr. Weinstein.
Thank you.
Also in the slides that we have handed up to the court, if that's more convenient for you. But what you'll see here is the history of price reductions over time in the App Store, starting with the initial reduction. I'm going to have to bring it back. Starting with 2011, when the reader rule was introduced. The reader rule, of course, Your Honor, also allows developers to sell content outside the App Store, outside their apps on the App Store. Thank you. Outside their apps on the App Store and make it available to consumers on the App Store without paying any commission to Apple. So the reader rule also constituted a commission reduction in certain circumstances from 30% to 0%. We already talked about the multi-platform rule. In 2016, Apple reduced its commission to 15% for subscriptions after the first year. And in 2016, Apple introduced a commission of 15% for participants in its video partnering program. And then finally, this year, Apple announced a reduction in commission to 15% for small business developers. Now, I know the court has expressed a view that that may have been influenced by litigation or regulatory concerns. Nevertheless, it is a real reduction that has had real impact. And litigation and regulatory concerns are themselves a form of competitive pressure.
Does that mean that we have to wait for people to sue Apple? I mean, that's not something that, certainly as a federal court, I don't want to encourage litigation. But how can we reasonably say that should be a competitive driver?
I am not suggesting it should be, Your Honor. I am just simply suggesting that to the extent the court considers it to be motivated by that. Now, the evidence on that is to the contrary. Mr. Cook testified about the primary motivation being a desire to help the pandemic. I just understood that during the course of the hearing and the proceedings here, Epic has suggested there was a different motivation and thus the conduct should be discounted. My only point is that the conduct exists regardless of the motivation, and that the conduct has in fact spurred competition, again, regardless of the motivations. Google has now announced that it is going to have a small business program with this 15% commission. So the conduct spurred competition, whether you look at it as motivated by one factor or another.
Okay, response.
Thank you, Your Honor. Two main points, one with respect to the surveys and one with respect to price reduction. I'll try to get through both. With respect to the surveys, it's interesting to see the survey results of kind of an overall assessment of satisfaction, but that doesn't tell the full story. I'll show one slide with that taken from a survey which is in the record. It's PX 2284. I'm going to have to take it out of my phone to make it. What this slide shows is a deeper dive on satisfaction. And what it shows, and it shows pretty consistently over time, as Your Honor will see from these surveys on a yearly cadence, is there is satisfaction with some elements of the App Store. And in particular, one element that tends to get satisfaction from developers pretty regularly is the first one here, which may be a little hard to read on the ammo, but what it says is it refers to tools that are provided to develop the apps. And there does seem to be a level of satisfaction with the software tools that Apple provides people. But you can see in the other categories, the satisfaction levels are down in the 30s and in the 20s. And these are about profitability, about search and discovery, and about marketing and promotion. And these are important components of this transaction platform.
So this is 5 years ago, right, 2016?
Yes, Your Honor. I picked this one just because it has everything on one page like this. This is not a format that Apple has done year after year. In the survey in different formats in subsequent years. This one was just graphically nice for a slide. And to say, we've done a good job overall, what it does is it masks the different vectors of competition that would occur if there were other stores out there. Somebody else could say, hey, I see that Apple's not doing a great job on search and discovery. So I'm going to innovate, and I'm going to come up with something that developers and consumers will like. Or I see that Apple's not providing appropriate tools for marketing, and I'm going to come up with something that developers will love that will help them market their products. And that's the kind of vector by vector, factor by factor competition that would occur.
Are you also saying that a store would be able to develop the tools to develop the apps to exist on the iOS platform?
Your Honor, I don't think those tools are part of the store. I realize that Apple has characterized them that way. Those are part of the iOS platform. And as Dr. Evans explained in some detail, the operating system platform is very different from the App Store, which is a distribution channel to get apps out there. And you need look no further than the Mac to see how that's so. There are tools that are provided for developers to make apps for the Mac, but that's not part of the Mac App Store. people get tools to develop applications for the Mac that they can then distribute through Steam or the Epic Games Store or directly from their own website. So the tools are not part of the store. So that's how I think about the question that the court just posed. As for developers being satisfied and the evidence we have, I would ask, as I did to Mr. Cook, where are the developers coming forward and saying to this court, we love what Apple's doing? There are none. Everybody who's come here has been complaining, which is shocking, really, when you think about the fact that the people who have come forward have a lot to lose from Apple retaliating in the way that we've shown they have done against Epic and in their change to their developer program, which entitles them to continue to do that in the future, notwithstanding the claim that somehow that retaliation seems to have been required by Japanese law, which didn't make any sense whatsoever. The other point that I'd make, Your Honor, in broad category of topics in response to Ms. Moyer's comments relates to whether or not there's been competition that's been felt and whether the price changes that have occurred have been the result of competition. So a few comments on that. First, Ms. Moyer said that the conduct exists, and that's enough to conclude that there's been competition. Not so. There's no record evidence that these things that have happened have been the result of Apple feeling pressure and competition. I do hear Ms. Moyer cited some testimony here from Mr. Schiller, and it's interesting that he said that here, but there is nothing contemporaneous in the record that shows that Apple was feeling the pressure to lower its prices because of the possibility that developers would switch or go elsewhere. What we see instead is effectively it's like the benevolent overlord theory of antitrust law. We're doing a good job, so just let us keep doing it, instead of what the antitrust laws expect, which is competition to spur people to do better than they're doing. It's not enough to say, we're a great company, we've been doing well, and, so I think we all know that that justification didn't hold up to the documents. But saying we're benevolent folks and we're talented is not enough to say we should get to have this market to ourselves. What the antitrust laws assume is that if there is competition, then people will do better. That's what forces them to do better. Mr. Cook said, I don't think people should have to make that choice. Mr. Cook said, seems like a complexity people shouldn't have to deal with. But when he was pressed, what would happen if there was another store on the iPhone? He finally gave away the game, no pun intended. What he said at pages 39, 34, and 35 of the transcript was, quote, we'd have to differentiate in some way. But just so, Mr. Cook got that exactly right. If they had competition, they would have to continue to work to differentiate themselves, and that would be a good thing.
So you made a reference to, in terms of anti-competitive effects, in terms of conduct, you made a reference to, obviously, the lack of price decrease. So we don't have, there are different ways that you have all sliced it in terms of increase or increase or decrease, but we got the 30%. That's pretty obvious. There's a substantial amount of evidence in terms of output, which is increased. Sometimes, right, among the factors, output can be reflective of any competitive conduct. So you don't really have an output argument. Now, whether or not it's how it's relevant, haven't figured out. But output is one. Quality is another. What specific direct evidence is there of anti-competitive effects? List them. Just list.
Just list, you said.
Just list.
Sure. And after my list, I'll make one point. But in terms of specific anti-competitive effects, number one, higher prices. There are higher prices than there would be for app distribution if there were competition. Number two, there would be more innovation in the market for app distribution. And I want to be clear, that is the market that we're focused on when we're having this discussion. There would be more innovation in app distribution. We're not talking about innovation on the phone or innovation on the operating system. This is the case about app distribution, and we would see more innovation there. We would see more innovation with respect to the in-app payment solutions, which we talked about on the other part of our plan. And you would see overall, once you have lower prices and once you have more innovation, you would see better output even than we have seen so far. And this is the other point that I had wanted to make after my list, is it's not enough just to say there's been a lot of output. As Dr. Evans testified, you can't form a view on any competitive effects without considering what would happen in the but-for world. It's a comparative exercise. Otherwise, you would never see an antitrust violation in a dynamic market like this one. But we know that's not the case in cases like Microsoft and others. And lastly, on my
better.
I apologize, Your Honor.
How do you define better?
Lower prices, more innovation.
That's 1 and 2.
Correct, Your Honor. Those are the classic vectors on which you measure output in an antitrust case: price and quality. We'd have lower prices, we'd have higher quality, and innovation is, of course, one way of thinking about quality.
Right,
the other thing is, apologies.
You gave me your list for response.
Yes, Your Honor. First, I would like to just briefly address a couple of the points that Mr. Borenstein made about developer satisfaction. Quickly, just the 2016 survey he showed, really the court needs to keep in mind that there was a huge effort to improve the App Store starting in 2016. And so the latter data should be the focus of the court's analysis in terms of the current state of affairs with respect to the App Store. Also, Mr. Borenstein shared his view that the tools are not a part of the store. And I think that's interesting for Mr. Borenstein to share that view, but Apple has testified, Apple witnesses, numerous Apple witnesses have testified that the tools are in fact an integral part of the store. The tools are provided to developers so that they can have apps on the store. Apple invests enormous amounts in research and development, and the amount increases year over year, Your Honor, in part to develop these tools that enable developers to have wonderful offerings on the App Store. And so the notion that those tools are somehow separate and can be disaggregated from the store, the evidence does not support. And then Mr. Borenstein criticized Mr. Cook's testimony about differentiating its product. And, Your Honor, that testimony really gets to the heart of the issue before the court, because Apple very much wants to differentiate its ecosystem. As the court mentioned earlier, consumers buy into that ecosystem with a specific expectation based on Apple's long-standing brand promise of enhanced security, enhanced privacy, enhanced safety. And yes, Apple very much wants its product to remain differentiated from the type of Android product that Epic wants to force it to offer. Right now in the marketplace, consumers who want what Epic is advocating are free to obtain it. It is freely available. Anybody who wants a system that would allow the sideloading, that would allow these alternative stores, is free to go out and buy an Android device. The relief they're seeking here is to force Apple to take a competitively differentiated product off the marketplace. And, Your Honor, while it may not make sense to Mr. Borenstein, it certainly makes sense to Apple, and it's kind of the heart of Apple's competitive strategy.
Okay, response.
Yes, John. So two things. First, I appreciate the fact that Apple witnesses have come in and testified that the tools are part of the store. But it frankly doesn't make any sense in the context of this industry, as shown, as I said, by the Mac. People who have operating systems make tools so that developers can write to the operating system. It happens on the Mac. It happens on Windows. That's how it happens on Android. People make tools so that people can write to the operating system, whether they have their own store or not. These are two analytically separate things. It just so happens on iOS that there is no other store, there is no direct distribution, and so there's no other way to get your app onto the device unless you go through their store. But the tools are the tools, and the tools are a set of software that are used to write the app. How that app then gets onto the device is an entirely separate question. So there's no analytical justification for this linking together of software tools to create a program and the creation of the store itself. And in fact, there were tools that existed before the store. But Apple wrote its own apps using tools to have apps on the store, have apps on the phone before the App Store even existed.
All right, Ms. Moyer, I'll let you respond to that. And also, I cut you off before you could respond to the effects, namely higher prices, less innovation.
Yes, thank you, Your Honor. In response to that point, I just remind the court that Epic, in its sworn interrogatories, has admitted that they cannot develop apps for the App Store without the tools embedded in Apple's IP, the tools that Apple licensed to it. I don't know why Mr. Bornstein thinks there's some distinction in light of that admission, but that's the evidence that is before the court. So really the parties are aligned on this issue with respect to tools. And before turning to the issue of commissions, I just quickly have to mention, because we heard a reference to it now and we heard it in Mr. Cook's cross-examination, why have no developers come to Apple's defense? And it is because we have not gone out in the world and searched and jumped on airplanes and jumped through all the hoops that Epic apparently did in a desperate attempt to get some rebuttal witness to come into the court on the last day of trial. So I could have certainly asked Mr. Cook whether he was aware that Epic was not able to scrounge up a witness at the last minute after jumping on airplanes.
I think that's not exactly true, right? He's talking about Down Dog. They testified in their affirmative case. And then we've got deposition testimony from Match. So that's not quite fair.
No, I agree, Your Honor, they have had developers. I'm just addressing the theatrics of asking a witness whether they were aware of litigation strategy decisions. And of course, I could have engaged in the same theatrics, but did not feel like that was appropriate. Turning to the commission and the output and the price increase issues. First, I'd like to point out that Apple's 30% commission, the 30% rate that some pay, has always been competitive. That 30% commission was competitive when it was introduced, Your Honor, and it remains competitive with the rate that is offered on all the platforms that you see here. This is a slide that was used in Mr. Hick's testimony. And you see the admission there from Tim Sweeney himself. 30% is the most prevalent rate charged by the stores, and it was then, and it is now. Your Honor, there's no evidence of any super competitive price. The evidence is unrebutted that the 30% is competitive and that there have been price increases over time. In terms of output, this is also a chart that may be familiar to Your Honor. This is a record of the output effects in the digital games transaction market. This is the market that we believe is appropriate for assessment of Epic's claims. And you will see there has been an explosion in output in that market. There are a 1,200% increase between July 2008 and September 2019 in the number of initial game downloads and in-app purchases on the App Store. There has been a 2,600% increase in developer revenue from App Store initial game downloads and in-app purchases in that same time period. And these output effects are not only limited when you assess them in the market we propose, Your Honor. We see the same type of staggering output in Epic's alternative prepared markets.
So anti-steering provisions and anti-competitive. I understand that Amex held to the contrary, but as I indicated, and I'll again go back and check the record, in Amex, the market reality, I suspect, was not the market reality here, which is that people don't know. And Apple's hiding of that information as in a way that is not reflected to the consumer directly seems to be anti-competitive. So address that topic.
Yes, Your Honor, I'd be happy to. Just a couple more slides on that. First, Your Honor, I'd just like to point out that there is nothing unique or unusual about the use of anti-steering provisions. They are really common in digital marketplaces, and as ethics expert Professor Evans testified, when you have these kind of common practices, then you have prior information that they're efficient, that they're used for efficiency purposes. Apple's witnesses,
it's not for efficiency here. Mr. Cook conceded that it's not for efficiency. He conceded that it was a method of being compensated for intellectual property. And I understand Apple has a right, in my view, to be compensated for their intellectual property. One of the issues we'll get to with Apple, because they seem to be wanting access to users without compensating Apple for that access. But he conceded that that was not the reason.
And Your Honor, you are correct, and I actually have Mr. Cook's testimony to review with the court. Okay? First, both Mr. Cook and Mr. Schiller confirmed the limited nature of the anti-steering provisions that Apple employs. Both confirmed that developers remain free to engage in mass marketing to customers, mass marketing that includes information about other payment options and about lower prices on other platforms. In fact, Mr. Schiller, I have this testimony for you. Confirmed that he himself received mass marketing from Epic, the plaintiff in this case. So there is no gag in place, Your Honor. Developers are free to market to their customers in any way they see fit. They can put out newspaper ads, they can put stuff on their website. The limitations that Apple has are that you can't link directly on your app in the store to another payment processor, and that you cannot use a curated list of those email addresses you obtain from registration on our platform to be targeted marketing. And here's the testimony on Apple's reasons for that. Your Honor is correct that Mr. Cook said if we allowed people to link out like that, we would in essence give up our total return on our IP. So yes, we believe it's a legitimate business justification to not have people have links into the apps on the App Store asking people to circumvent payment online.
All right, so maybe not a link. Why not something that merely says more options available online?
It would be the same. It would be the same rationale, Your Honor. It would be, as Mr. Shiller said, like asking Nordstrom to allow Macy's at the checkout counter to have a sign that says you can also buy over at Macy's for another lower price. Maybe you want to consider purchasing elsewhere right as you check out. This is kind of
but in the Amex analogy, I go to the checkout stand. It says Amex, MasterCard, Visa. So you're given options.
And developers have options here. There are only two narrow limitations, Your Honor.
Narrow? I don't know that you can say it's narrow given how profitable it is.
Given how profitable
in-app purchases are? Can you really say narrow? Given how profitable it is?
I understand that in-app purchases are very profitable, Your Honor. What I was referring to is that the limitations on developers' conduct are narrow. They remain free to engage in all other types of competitive conduct.
But can we get some clarity on this, Mr. Bornstein, from your perspective? The way that Ms. Moya has described mass marketing, I thought I went back and read some of the testimony from Down Dogs. It seemed to suggest that they thought that they couldn't send emails to customers. I'd like to hear your perspective on this topic, and again, I'll have to go back and check the record myself.
Absolutely, Your Honor. Just to commend the court to the place to look with the authoritative explanation of this. It is, of course, the app review guidelines, and the relevant ones are 3.1.1 and 3.1.3. And to address the specific question about email, Ms. Moye referred to it here. I won't comment on, because I frankly don't recall whether she got it exactly right or not. But the language in 3.1.3, it says that you cannot, either within the app or through communications sent to points of contact obtained from account registration within the app, like email or text, encourage users to use a purchasing method other than in-app purchase. And so when Mr. Cook, for example, kept saying, you can do it if they give you your email, what that means is that the developers need to get the consumer's email through something other than their signing up on iOS. They have to find some other way to get people's email so that they could then send them some kind of mass marketing. What Apple prohibits is sending mass marketing emails, texts, and so forth to people at points of contact that were obtained within the app.
Yeah, but Fortnite, there is evidence in the record that Fortnite sends emails to Mr. Schiller, who signed up, I thought, through, well, I'd have to go back and check how he signed up. But if someone has the email, which Fortnite requires as a, for instance, because you sign in, I think, right, to your Fortnite account with your email, then they can send that information.
So
at least with respect to Fortnite, we know that it's not limited. Is that right?
So there are different categories of apps under the rules. 3.1.1 and 3.1.3 cover different types of apps, and the limitations are not precisely the same in the rules as to each type of app, which is why I started by commending the court to take a look at what's in the guidelines themselves. What's clear is the restriction prohibits for apps in 3.1.3 those kinds of marketing communications. For other apps, the restrictions are not exactly the same. You cannot have a link. You cannot have a call to action. I'm sorry, Anna.
What are the categories in 3.1.1 and 3.1.3?
So my understanding is that 3.1.1 is kind of a general rule, and 3.1.3 about a set of categories, which are then listed in 3.1.3A, B, C, and so forth.
Okay.
I can read them to the court. I was just trying to save Your Honor the CDM.
I just want to have a sense, because earlier you said that clustering was not appropriate, and yet if the anti-competitive effects impact certain categories of apps that are not impacted by a different set, then perhaps you're wrong that clustering is not appropriate.
So I disagree with that, Your Honor.
Okay, could you tell me, just generally, give me some sense of the categories?
Sure. So the ones that fall in 3.1.3 are things like the multi-platform services that Ms. Moyer and I think maybe Mr. Swanson talked about a little earlier, which would include an app like Fortnite, where you can buy on one place and go somewhere else. The reader apps, which we talked about, like Kindle, and I think even Netflix fits in that category, although you're not reading, you're watching. It covers what are referred to as person-to-person services. So if you take a class and it's just one person and the teacher, as opposed to Down Dog, where it's a teacher and a big group of people that is treated separately. There are a few others that I'm less familiar with, frankly. Oh, enterprise services is another one that fits in that category.
Okay.
And there are a few more, and they're all here in the guidelines.
Okay. So what does account registration mean?
My understanding is it's signing up for an account with the app. A lot of apps ask you to sign in.
Is it defined in the guidelines?
Not that I'm aware of, but I'm not 100% sure, Your Honor, but I don't believe so.
All right, will you address that topic specifically, please?
Yes, Your Honor. I have a copy of the guideline provisions. I thought it may be helpful to put them up on the screen. So 3.1.1 applies to in-app purchases. And you'll see that the language in 3.1.1 talks about linking out and calls to action. So if you are offering in-app purchasing on your app, you cannot include those kinds of links. The 3.1.3 provision that relates to Epic is the multi-platform rule. Because remember, Epic is allowed to sell its products, its V-Bucks, off the app and allow customers to use them on the app. So what this rule says is that you cannot, I'm going to have to borrow it for a second. Directly or indirectly target iOS users to use a purchasing method other than in-app purchases. And your general communications about other purchasing methods must not discourage use of in-app purchase. What Mr. Schiller testified and Mr. Cook confirmed is that developers cannot use the email addresses that they obtain when consumers register for an app there by themselves to target those users. That developers are free to send emails to their customers as long as they get the customer's permission to send those emails. That would include those who initially registered within the app. So as long as it's not a targeted solicitation based solely on account registration within the app, then there's not a steering concern. And Your Honor, I know that this is an issue we've spent time on, but it's important to keep in mind that Epic has not raised a legal claim here saying that it has been harmed as a result of any anti-steering provision. Epic has neither claimed that, and there's not a scintilla of evidence in the record showing that Epic has suffered any harm as a result of these anti-steering provisions. In fact, there's no evidence in the record that anyone has suffered any harm as a result of these anti-steering provisions. The evidence that is in the record,
the Down Dog developer certainly said that they were harmed by that.
And I have a snippet of his testimony, Your Honor.
I don't need to see it. I'll go back and read it,
okay.
But you can respond.
Because I believe his testimony was that his purchases through the subscription option remained the same before and after he had this availability of
But he
subscription.
testified that there was a measurable difference for those who were signing up on Android.
What I have here is his trial testimony at 416, starting at line 7. And I think it was in policy with the court.
I can go back and read it myself. But I thought that there was some evidence with respect to that. But I'll check. I take your point that they have not claimed this as an issue. Agreed or not?
Disagreed, Your Honor.
Where in your
interrogatory number 13, in response to a request from Apple, we made the point that this is one of the provisions that we were challenging, and in our discussion in the findings of fact and conclusions of law, we do address this restriction as well. It's just incorrect as a matter of fact.
Okay.
Speaking, if I could address a few other points in there, with respect to Down Dog, Your Honor is correct. There was a vast difference between the signups on iOS versus Android, given the presence of the anti-steering restriction. And Your Honor may recall that they actually conducted an experiment where for a period of time they attempted to make the Android app mimic iOS by removing the link that Android allowed. And it resulted in a 28% overall drop in subscriptions, overall, output reducing. Another point is...
he gave me a slide that seemed to indicate that all of those other platforms use anti-steering measures. Your response on that point?
Yes, Your Honor. None of those other platforms, with the exception of Google Play, has market power. Right? Just like Amex, the government did not prove that Amex had market power. It's an entirely different situation when you're dealing with an entity that has market power versus an entity that doesn't. This is another situation where Apple is creating a false equivalence, like with the consoles and all of the stern and drawing around the possibility that the ruling here that's adverse to Apple would be bad for the console makers. As we know, there's at least one console maker who doesn't think so, because a business person from that entity came here and testified, and Apple has even gone so far as to say in a filing recently that maybe Microsoft is behind this whole case, and Epic is a proxy plaintiff. And they've gone to the level of that kind of conspiracy theory. But if that were the case, Microsoft sure would be acting against interest if this was going to doom its own Xbox. One other point I should make, Your Honor, just so the record is clear, I'm not sure why, but the version of the guidelines that Ms. Moya just showed you is outdated. Those are the 2020 guidelines, as it says on her slide. I have the 2021 version, which is in the record as Exhibit 2790, and the language is different. I apologize for having the highlighted marked up copy, but this is my own personal copy that has received my attention over the months. But you can see 3.1.3 has the language that I read to the court earlier, that it prohibits not only links within the app or calls to action within the app, but also communications obtained from account registration within the app. And it's worth noting, by the way, that this provision really only has bite where you have people who sign up, right? So if you have a multi-platform service, for example, like Fortnite or Netflix, that's when you're going to have an email that you might, as a developer, want to send something to. If you have a one-off app that is not a multi-platform service, you're much less likely to have the email in the first place. You know, my flight view app that I use to check if my flight's on time, they don't have my email, but it's not a multi-platform service. It's not uniformly true, but the multi-platform ones are the ones that you're much more likely to find yourself in this situation. And I presume that's why Apple has drafted the guidelines this way, because that's when the developer might have the email to send something to the consumer.
But the developer could ask for the email. There's no restriction in asking for the email.
That is true.
And then once they have the email, then they can market through the email.
That is my understanding. It's an extra kind of step of friction that the developer needs to go through.
Others might say privacy.
Well, it's another step that needs to be gone through to get that email. There's no privacy issue here because the developers have the email. It's not a question of whether they get them, right? Fortnite has Mr. Schiller's email from when he signed up.
But like you said, let's say the flight app doesn't have your email. So let's say the flight app all of a sudden wanted to sell you currency to where you could buy things in the airports, and they didn't have your email. I'm just trying to understand, right? So it sounds like if they asked you for your email and you agreed to give it to them, then they could send you an email that said, "Welcome to our app. Here's some offerings that might be of interest to you."
Yes. Although they couldn't, they couldn't do a targeting in the app for an app like that to say, we'd like you to go purchase elsewhere. You can't have a call to action in the app, even for an app like the Flight app, which is not multi-platform. And just to address a little bit more on the anti-stealing, we've done some analogies about Nordstrom and Macy's and the like. I think if we're going to do a kind of shopping analogy in a mall, a better way of looking at it would be when you go to the mall and you go shop at a chain store like Under Armour or whatever. There are situations where the store will have a sign that says we have stores elsewhere. Right? We're not only here. We have an outlet in this other mall over there, or we have an outlet downtown, and that's perfectly acceptable. The reason I raised it is because stores often are required to pay some portion of their revenue to the mall. That's how the mall makes money. But the mall doesn't prohibit you from saying, hey, you can buy from us somewhere else. That's perfectly ordinary. And the Amex example is probably much more on point since we're talking about shopping. As the court has said, in that circumstance, there are signs at the window or at the cash register that say you can use Visa, you can use Amex. Once upon a time, as the court pointed out, maybe you could use Discover. But those are possibilities. So the rule that we're dealing with here is much more restrictive, and it is imposed by a company unlike Amex and unlike the others on that slide that Ms. Miller showed, with one exception, a company that has market power.
Yes, Your Honor. important to point out that you did not hear in that response was any reference to evidence in the record that any anti-steering provision has harmed Epic. Now, with respect to the testimony of Mr. Simon from Down Dog, I actually have the correct testimony for the court now. It's trial transcript 418, starting at line 16. The court. Okay, how long did you...
Don't read it to me.
Okay.
418, what's the...
Line 16.
All right, I'll take a look.
And there he just confirms, Your Honor, that he had a link up for a while and that it had no impact on his sales on either platform. So there's no evidence in the record to support harm. The final point...
I was just going to, if we're doing dual insights to Mr. Simon's testimony,
Yep.
I would commend the court to 359, 361, which is where he talks about the differentiation between Android and iOS.
Okay.
And then 363 through 367, where he talks about this experiment and the actual concrete harm that occurred when he removed the link.
Okay.
And then just one... Okay.
Diane, how are you doing? Do you want to break now? Okay. I mean, we'll have a while to go, so. Okay, you want to finish?
Yes, I wanted to make just one final point with respect to this anti-steering assertion. The assertion that there's concern about anti-steering is contradictory to the assertion that there is an iOS-only market. The fact that Apple feels the need to have an anti-steering provision is absolute proof that the Apple platform competes with those other platforms to which consumers could be steered. So Epic can't have it both ways. They can't prevail on an anti-steering claim while maintaining that there's an iOS-only market.
Your Honor, I've been relatively, I hope, restrained in the language I've used so far, but that little piece of it is kind of economic nonsense. The market is defined by having sufficient substitution to discipline the monopolist in exercising market power. It does not mean that there is absolutely no substitution at all. Of course, there's substitution at the margin, especially when you have a monopolist who is already charging a price that is above competitive levels. But it is completely incorrect to say that there is no need for an anti-steering provision when there's just the market. Apple is absolutely interested in preventing the marginal customer from switching over or shopping somewhere else. Those two things are entirely consistent with one another.
Okay. I am going to give my court reporter a break because she knows I can keep going, but that would not be nice to her. And she's.
Your Honor, I appreciate the break too. Thank you.
Thank you.
Okay, we'll stand in recess for 15 minutes.
Thank you.
come back too bad. I'm not turn their backs in the past, now they wanna come back too bad. I'm not practicing forgiveness. Realize that they fucked up, now they see me get some. Can't eat while you standing in my kitchen. Yeah, I remember when you talked down, hands out, thinking that you getting some odds now. If you weren't there for the grass rules, I can't let you in, I'm sorry to break the band.
Okay, they still up in that beta stage. This should go and wake them up. 200 for a saving grace. I feel I wasn't paid enough. Predicting what I complain about when Ollie catch a major buzz. Hundreds too freshly pressed. Watch out for them paper cuts. The dude working, the tour coming. I'm poured up. The new burden is getting room service in foreign tongue. Boarding a Bombardier to fly to where I'm born from. And when I land a bad Insta influencers swarm us. Women, they loving the dude. I can't fall or bear the thought. I fuck him, it's something to do. They quick to have the marriage talk. And no one can fit in my shoes, so they watch it where I walk, but can't mimic. They cramp sprinting the caste system. I was born for it. 4th and inches, I'm going for it. I can't wait to trade for the skate for foreign plates. 4 mortgages, all of them out in Florida. There's gotta be more to this. Can't bring you if you ain't on the list. Turn their backs in the past, now they wanna come back. Too bad I'm not practicing forgiveness. Realize that they fucked up, now they see me get some. Can't eat while you standing in my kitchen. Yeah, I remember when you talked down, hands out, thinking that you getting some odds now. If you weren't there for the grass rules, I can't let you in, I'm sorry to break the bad. When I get a mansion up in the canyons, I'ma go pass this shit to my dad. I'm putting my mama on the yacht, putting Sebastian up in the fastest. With the Jag back to Jacksonville, get Stephanie Cabal. Cause when I'm on and I don't give a fuck, I'll definitely need it all. Not just talking, I got a knack for making it come to fruition. Came in thinking you get famous, boy, I've come to do business. Seen a ton of all of it happen, they only fuck if you winning. Pussy or push me into distraction, can't keep none of you winning. Don't be turning on them read receipts, hoping that you teasing me. Jokes on you, bitch, you're not the only girl that's seeing me. You get through with your features, opportunity seeker. You think you get smooth, talk me hard, truthfully speechless. Cause I work for this, I stay the way. Pay the lane and stay the same. Invest in me if you want me to take you in and break the bank. And to all you broke hoes and my past friends who chose to shut the door on me, I'll never let you back in. Turn their backs in the past, now they wanna come back. Too bad I'm not practicing forgiveness. Realize that they fucked up, now they see me get some. Can't eat while you standing in my kitchen. Yeah, I remember when you talked down, hands out, thinking that you getting some odds now. If you weren't there for the grass rules, I can't let you in, I'm sorry to break the bad news.
Stressed all the time, I've been making my worst mistakes of my life. Still been searching for purpose. I don't know why all this pain finally surfaced. Stressed out my mind, made mistakes, but I'm learning. And I've been making all of the worst mistakes of my life. Mistakes of my life. Try so hard to keep it together. I'm running for cover, but that don't suffice. What's wrong with me? Feels like all these songs we're making just ain't songs to me. Just a way to ventilate the demons calling me. Just a way to keep me sane so they won't bother me. And I'm sorry I don't answer when you call me. I know you've been worried. Really nothing against you, just the way that I am. All the pain that I've been dealing with is gone in my head. No, pain goes on and on. I'm thankful, I'm so fucking grateful that I never let go.
Screaming all these melodies inside of my head. I hope I hear them when I'm fading, racing thoughts in my bed. I'll make you proud, I won't quit now. When there's nowhere to run, I'll stand my ground. Oh, I've been down one too many times, but I'll fight till I can find the light. I've been there, done all that before. Don't care what's one more war. I'll be here if you need me, I swear. I drag you down, but I know you still care. And if you hear me, I'm so sorry. I'll be better in the morning.
Pain goes on and on. I'm thankful, I'm so fucking grateful that I never let go. And I've been my life. Try so hard to keep it together. I'm running for cover, but that don't suffice. What's wrong with me? What's wrong with me? Pain goes on and on. I'm thankful, I'm so fucking grateful that I never let go. I told you, get out of my face. I just need space, no more time to embrace. Beat me to the finish line, it's feeling like a race. Yeah, I'm moving fast, so you pick up. I told you, get out of my face. I just need space, no more time to embrace. Beat me to the finish line, it's feeling like a race. Yeah, I'm moving fast, so you pick up. I told you, get out of my face. I just need space, no more time to embrace. Beat me to the finish line, it's feeling like a race. Yeah, I'm moving fast, so you pick up the pace. And I don't know why I've been so down. Can you come right now before I go insane? But baby, don't lie to me. Baby, I could give you everything. Baby, you know I am the one for you. Yeah, do you remember the first time you fell in love? 'Cause I remember the first time you said you loved me. I told you, get out of my face. I just need space, no more time to embrace. Beat me to the finish line, it's feeling like a race. Yeah, I'm moving fast, so you pick up. I told you, get out of my face. I just need space, no more time to embrace. Beat me to the finish line, it's feeling like a race. Yeah, I'm moving fast, so you pick up. I told you, get out of my face. I just need space, no more time to embrace. Beat me to the finish line, it's feeling like a race. Yeah, I'm moving fast, so you pick up the pace.
Tells me I don't know love. You don't really treat me like you should. I say I know love. Be a better man, I know I could. I'm trying to grow up. Sorry for the hold up. Hate when you don't show up. Girl, it really hurts me when you say yeah. I've been working on myself lately. Self-made and I felt crazy. Cause girl, I really wanna treat you right. And with this crazy life, I'm needing help, baby. And I've never thought about us giving up. Cause you are mine and now this is us. Feel I never seem to give enough. But I'm working hard to be rich as fuck. And I'm distracted browsing my phone. You hate the feels when you alone. I'm here but gone in my zone. You say you feel I'm outgrown. I hate the fact I never kept my promise to stay the same no matter what I profit. You say you miss a man you fell in love with. Then it hurts to know you think I'm changing constant. I'm sorry. Know this year has been up and down. I'm blessed that baby you love me. My emotions have shut down. She asking what the fuck are we? I hurt you bad. Coming home fighting worse than last. Ignore her feelings then I turn my back. Crying on the floor. She tells me I don't know love. You don't really treat me like you should. I say I know love. Be a better man. I know I could. I'm trying to grow up. Sorry for the hold up. Hate when you don't show up. Girl, it really hurts me when you say that I don't know love. You don't really treat me like you should. I say I know love. Be a better man. I know I could. I'm trying to grow up. Sorry for the hold up. Hate when you don't show up. Girl, it really hurts me when you say yeah. Friends saying just leave me. Both know it ain't easy. Cause every time we had ups and downs, we worked it down, you believe me. I know I need to stop saying sorry, start changing how I'm gonna act, yeah. Going back to my old ways, ain't gonna keep us intact. Now why you gotta pack, girl, I really mean it. Sick of the fast life, wanna take the scenic. Say you won't believe me till I prove it, you can see it. Here you call me the meanest, but I leave the cut untreated. No, it's only me to blame. I've been caught up with the change, I've been caught up with the game. Guess I really missed out, trying to be rich now. That ain't really shit for a girl that would stay, yeah, baby, just wait. Know you busted. You don't trust that, I ain't gonna just break up. When you undress, you just suspect. I don't think that we make love. Babe, I swear it. Work on us and no one never perish. Once I make it, then we'll fly to Paris. And I'll never hear you say, I don't think you know love. You don't really treat me like you should. I say I know love. Be a better man, I know I could. I'm trying to grow up. Sorry for the hold up. Hate when you don't show up. Girl, it really hurts me when you say that I don't know love. You don't really treat me like you should. I say I know love. Be a better man, I know I could. I'm trying to grow up. Sorry for the hold up. Hate when you don't show up. Girl, it really hurts me when you say yeah.
You don't know love. You don't know love. You don't know love. Show me that you know love, baby. Show me that you know love, yeah.
She tells me I don't know love. You don't really treat me like you should. I say I know love. Be a better man, I know I could. I'm trying to grow up. Sorry for the hold up. Hate when you don't show up. Girl, it really hurts me when you say that I don't know love. You don't really treat me like you should. I say I know love. Be a better man, I know I could. I'm trying to grow up. Sorry for the hold up. Hate when you don't show up. Girl, it really hurts me when you say yeah.
All the times that I told you I love you, I guess that ain't mean shit to you. And I'm starting to think that you not even listening. What the fuck did I say to you? I will travel that far across the whole road, yeah, just to give my love to you. But you acting rebellious, you won't take anything that I try to get to you. All the times that I told you I love you, I guess that ain't mean shit to you. And I'm starting to think that you not even listening. What the fuck did I say to you? I will travel that far across the whole road, yeah, just to give my love to you. But you acting rebellious, you won't take anything that I try to get to you. Yeah, you won't turn your back on me, I'll never turn my back on you. Hey, I'll travel the road, yeah, it's to give my love to you. But you don't know what I do, you don't know what I do. Bitch, I'm done loving you, is this what you do? And I'm far from a fool, but that's not stopping you. I got nothing to prove, I got nothing to lose. I'ma let you go and do whatever you like. I got nothing to lose, unless it's my life. I got nothing to lose, I got nothing to choose. You was nothing to me, I was nothing to you. And my heart, it was fragile, there's nothing to move. A hard shit happened, there's nothing I can do. All the times that I told you I love you, I guess that ain't mean shit to you. And I'm starting to think that you not even listening. What the fuck did I say to you? I will travel that far across the whole road, yeah, just to give my love to you. But you acting rebellious, you won't take anything that I try to get to you. All the times that I told you I love you, I guess that ain't mean shit to you. And I'm starting to think that you not even listening. What the fuck did I say to you? I will travel that far across the whole road, yeah, just to give my love to you. But you acting rebellious, you won't take anything that I try to get to you.
Welcome to AT&T's teleconference service. Please. participant. For a menu of available commands, press *#. Your connection is now in listen-only mode.
Okay. We are back on the record. The record will reflect that the parties are present. Shall we move to remedies at this point? And then what we can do is, I will give each side time, trying to be uninterrupted at the end to make points that you might want to make.
That is fine, Your Honor.
Okay, let's move to remedies. I have Mr. Bourne at the podium with Mr. Bornstein. Mr. Bornstein, we'll start with you. One of the issues that has concerned me throughout the course of this trial is that your client does not seem to be interested in paying for the access to customers who use iOS. And even if he is interested, it's hard to see how we get there. Because he's attacking the fundamental way in which Apple is generating revenue, which I know you disagree that they are using it for purposes that assist, but there's a reasonable argument that they're using these profits to benefit the whole ecosystem. So I know there's some disagreements, but I still don't understand where you expect this to go. That is, yeah, go ahead.
Sure, Your Honor. So first, there's just a level set, as a level set on that point. Apple can stop. Go stop. Oh, can you not hear me, Your Honor?
No, I can.
Okay.
Somehow you cut out.
Sorry. So Apple can charge. There's no effort here to say that Apple must give away all of its stuff for free. So just as a baseline, that is not what Epic has advocated, is that they are obligated as a matter of law to give things away for free. It does happen to be the case that most general purpose platforms operate in that way. What Apple has done is structured its business differently. They're not obligated to follow a particular business model. What they are prohibited from doing is structuring their charges in a way that has any competitive effects. So here we have a structure in which there are any competitive effects in app distribution because they are the only path to get onto the iPhone. And we have any competitive effects in in-app payments because of the requirement that developers who want to offer digital content must use their solution. So the issue is not, can they charge something? And the issue is not can they charge people who make games. The issue is can they structure their business in a way that has the effect of artificially increasing price and artificially decreasing quality and innovation. And that's what we challenge. And as a remedy, we believe that the right thing to do is to get rid of those particular anti-competitive restrictions. And I have a slide I can put up and go through about the specifics of the remedy, but I don't want to go do that if I haven't been responsive to the court's question yet. Okay. You should have a set of slides, Mr. Dorn.
What page is it?
It's slide 88. And so what we've done here, Your Honor, is to try to break this down into the two different restrictions that are at issue and the type of remedies that are at issue for each. And you'll see we have two columns. App distribution restriction that relates to the fact that the App Store is the only way to get apps onto the phone, and the IAP requirement, which I think is obvious what that is intended to cover. And for each one, there is a primary remedy, some anti-circumvention, and then some interim steps. And this is all, by the way, in our January 22 submission. I've just tried to make it simple as a conceptual matter rather than more detailed. And so really all we're asking, Your Honor, is on the primary remedy to prohibit the specific restrictions that have these effects. And then the anti-circumvention steps are just to prevent Apple from getting around that main prohibition. And then on the interim steps, we have, and these are a little bit more involved, an effort to try to limit the extent to which these restrictions will impact Apple's business going forward, but at the same time making sure that the remedy that the court enters is effective to address the built-up consequences of the anti-competitive conduct that has existed for so long. And if it's helpful, I can go in more detail to any of these pieces, but they are all laid out in more detail in our remedial submission from January 22. But
the effect of both of these is that Epic Games would pay Apple nothing.
That's not correct. I disagree. It may be the effect if that's where the market takes Apple and what Apple is able to charge in the market. But for example, Apple can charge in a non-discriminatory way developers. Apple could choose to charge certain developers more than others based on the advantage that they take of the platform to try to be sensitive to that and to price discriminate in an appropriate way. But what they can't do is they can't charge in a way that has these anti-competitive effects on app distribution and on payment solutions. So we're trying to be targeted to address only the restrictions that we have challenged. And we expect, given the innovation in Cupertino, that they would find ways to continue to profit from their intellectual property and from their other contributions, but just not in a way that has these anti-competitive effects and that would result in charges that are driven by the market rather than being driven by the monopoly.
Your Honor?
Mr. Dorn.
Your Honor, it's a beautiful chart, but I think what they want is simple enough. And it does come out of docket 276 and their appendix A to that. They want 5 things. They want there to be no prohibition on side loading and an enforcement of that prohibition. They do not want Apple to enforce contractual provisions, guidelines, or policies or impose technical restrictions or financial penalties that restrict, prohibit, impede, or deter the distribution of iOS apps through a distribution channel other than the App Store. They want a compulsory license of all of Apple's intellectual property. The second thing they want is that all stores get access to all Apple functionality and features required to mirror the experience of the App Store. The next thing they want is that there be no warning signs and no indication on apps that are not Apple-approved apps, that in fact they have not been through the app review process or in any way touched by Apple. The next thing they want is that they get the same rights through the App Store itself, that other stores be able to be put on the App Store with complete access to all necessary Apple IP to mirror the App Store experience. And they also want that Apple be enjoined from restricting, prohibiting, impeding, or deterring the use of in-app payment processors other than Apple's IAP. Now, we just heard a theoretical musing about how sometime down the road the market might require that Epic Game Store pay something to Apple. But as Your Honor has correctly observed, what they want right now is to be able to put the Epic Game Store on the Apple App Store. They want to conduct business without going through IAP, and we know what that looks like. They have their own payment button. We've seen it. And under that model, nothing would be paid to Apple for the use of its intellectual property, for the use of the platform. Nothing would be going to Apple for that. And Apple, and we can talk about this when the court is ready to, and Apple would not have an opportunity to conduct a meaningful review of what's in those stores. And even if it did, it would now be doing it for free in an attempt to safeguard their customers, but an attempt that would fall far short of what it's capable of doing now. So Your Honor is correct that what Epic Games is seeking to do is not to compete on commission. It's seeking to avoid any commission. They want to put their store on our platform and charge their own commission of the people conducting business within it.
Response.
Yes, Your Honor. The description of the different pieces of what was that Mr. Dorn went through is, I would say, a paraphrase of what's in our Exhibit A. It is the case that we do think that there needs to be a prohibition on the restriction currently in place that makes the App Store the only store. And we do think there needs to be a prohibition on the requirement that IAP be the only way that people can offer digital content. We absolutely are not saying, and do not say, that Apple is prohibited from charging people for its intellectual property.
Are you asking for a compulsory license?
No, Your Honor. Absolutely not. Apple is more than free to choose not to license its IP. Right? Any patent holder can say, I won't license my IP. That's just fine. But when someone chooses to license its IP, it is subject to the antitrust laws. It cannot impose conditions on those licenses in a way that has any competitive effects. Your Honor made that point in the preliminary injunction opinion. In Microsoft, the way the court responded to the argument that intellectual property was a free pass was to call the argument bordering on frivolous. Conditions that are imposed on the licensing of IP are routinely scrutinized under the antitrust laws, and for good reason. Because you cannot, although there are things that you could choose to do unilaterally, like withholding your IP or refusing to deal, you cannot place conditions on those things if the conditions have any competitive effects. And Kodak makes that clear as well in footnote 8. Apologies.
Go ahead.
Your Honor, the IP guidelines make clear that the only time that the incidents which would have anti-competitive effects are where the license eliminate competition that would otherwise exist but for the license, and but for the license being in place. And here, Your Honor, but for the license, there would be no apps other than Apple's native apps on the iOS platform. Apple has chosen to license. It's made its choice. It could have kept it internally. It could have made all apps its own, but it made the business model decision to make apps available to consumers from third parties and to make the platform available to third parties to the great benefit of all, to everyone, including Apple, but including consumers and including developers. And to the extent we're asking whether or not Apple is being asked to provide a compulsory license, I once again take the court back, and here I am not paraphrasing, to lines at 276-1 at page 4. The prohibition must prohibit Apple from enforcing contractual provisions, guidelines, or policies, or imposing technical restrictions or financial penalties. Now, a moment ago, we heard counsel try to subdivide Apple's intellectual property, the intellectual property reflected in IAPs, away from the store in an apparent attempt to get around the fact that they had admitted on the face of their discovery that they could not be on the store but for that intellectual property. They could not have IAP purchases but for the StoreKit API, and that it is integrally and fundamentally a part of the store. It is a compulsory license. It is an attempt to profit from Apple's intellectual property without any compensation, and it is pro-competitive for Apple to have the business model that it has, as Ms. Moyer has discussed and can discuss it some additional length.
Your Honor, what I hear Mr. Dorn saying is we have IP, we can license it however we want, competitive consequences be darned. That's it, full stop. It's ours, we can do with it what we want, even if it has any competitive consequences. That is so facially, obviously not the law, it is shocking to hear Apple stand here and say it. Of course, if there are...
This is one thing. I don't hear him saying that. We all agree or disagree as to whether they're anti-competitive effects.
True.
I don't think Apple thinks that they've argued very hard that there are no anti-competitive effects. And so if there are, now let me ask Mr. Dorn, if there were anti-competitive effects, do you concede that IP is not a defense?
What I concede, Your Honor, is that there were anti-competitive effects in a market in which there would be competition, but for that license, that would be something the court should take into account in its antitrust analysis. But that's not the case here.
That respectfully is not responsive to the court's question. I agree with the way Your Honor phrased this a moment ago in clarifying what I said. Of course, I understand Apple disputes the existence of any competitive effects. 100%, I agree that is their position. They're having a conversation now about remedy, which means we've reached the point of concluding liability has been found. If there's no liability, the discussion Mr. Dorn and I are having with the court is academic. So if there is liability, that means there are any competitive effects. And if there are any competitive effects of the sort that leads to liability, the existence of IP is simply no defense. And the argument based on the IP guidelines or the interpretation of the IP guidelines that Mr. Dorn is articulating would have the effect of resulting in a world in which an IP owner could license in a way that has any competitive effects and then turn around and say, but there's nothing you can do about it because I've achieved those any competitive effects using my intellectual property. And that is just not the law.
Your Honor, this court explained in the jury instructions in the Apple iPod antitrust litigation, a company has no general legal duty to assist its competitors, including by making its product interoperable, licensing competitors, or sharing information with its competitors. And that was the jury instruction given in the iPod case. That remains the law today. Apple retains rights to use its intellectual property to compete in the business model it has chosen, the legitimate business model that was fashioned before anyone has ever asserted it had any sort of market power, and which has proved to be a great success for consumers and developers and Apple over the last 12 years.
There is no general legal duty to help competitors. I agree. It's also completely irrelevant to the question before the court. We're not asking for the court to order Apple to help us in the abstract. We're in a world now where we've found liability. That's why we're having the remedy discussion. And the only point that I'm making in response to the question the court has posed is, does the existence of intellectual property somehow restrain the court from remedying the anti-competitive harms that it will have found in the liability phase? The answer to that is no. This discussion about general legal duty to help competitors is not a remedy issue. It's a question of whether there's a duty to deal. It's a liability question. We're now having a conversation about remedy. the liability has already been concluded. IP is just not a defense.
As Your Honor has already noted, Apple does not claim that intellectual property is a global immunization, a vaccine, one might say, to antitrust liability. But into the facts here, the intellectual property is being properly used, properly licensed under a legitimate business model, and what Epic seeks here is a compulsory license without compensation.
If Mr. Dorn is correct that it's being properly licensed and properly used and not having any competitive effects, then he's correct and you lose on the merits and liability. But if he's not correct about those things, then we win on the merits and liability, and the court needs to be able to impose a remedy and not be handcuffed or restricted in the remedy that it imposes simply because IP is at issue. I think actually Mr. Dorn and I are kind of coming to agreement on this point.
So let me ask. Where courts have found antitrust liability let me take a step back. Courts do not run businesses. I mean, maybe the administrative office of the courts runs the business of the courts. But trial courts and appellate courts don't run businesses. In the cases where courts have found antitrust conduct, how have the courts fashioned remedies to deal with the antitrust conduct? Have they in fact said, you billion-dollar company, trillion-dollar company, you must fundamentally change the business model under which you are operating? Are courts doing that? Have they ever done that?
So the typical thing a court will do is impose a prohibition or a set of prohibitions on conduct that has any competitive effects. The characterization of change a business model or so forth, that is a characterization of the conduct. I mean, you can look, for example, at...
so give me an example.
Sure. As an example, it was reversed on the merits, but in terms of the remedy phase or the remedy decision in the Qualcomm case...
That doesn't help me. It's not binding authority, and it wasn't upheld. And perhaps perhaps they did it on the liability, but perhaps they didn't like the remedy and found that it would be easier to address the liability. So give me some example that has survived appellate review where the court has engaged in such a way to either prohibit something or to fundamentally change the economic model of a monopolistic company.
So Microsoft is an example that survived appellate review in part to recognize the most extreme remedies were reversed by the D.C. Circuit. But the court identified any competitive conduct there and upheld prohibitions on Microsoft's licensing and bundling practices and so forth with respect to Windows. And the case subsequently settled following the appellate decision. But there is a D.C. Circuit opinion governing the remedy there, and that is probably the signal example because it's one of these cases don't come along every day, obviously, Your Honor.
So let's talk about Microsoft. Again, let's assume liability.
All right, Your Honor. Well, first of all, Your Honor, that was a government case, not a private party case. And, of course, in imposing an injunction in private party litigation as a threshold matter, any sort of injunction should be as narrow as possible to address the complaints of the parties. But and secondly, Your Honor, as counsel just stated, Microsoft involved discrete prohibitions. Now, that is not what we have here. And in Trinco, of course, the Supreme Court told us that enforced sharing requires antitrust courts to act as central planners, identifying the proper price, quantity, and other terms of dealing, a role for which they are ill-suited. And if I might, Your Honor, I'd like to make a few record references. During the trial, there was some acknowledgement, at least by plaintiff's experts, that truly bad apps should not be permitted on the App Store. Now, Dr. Evans, Professor Evans, agreed that in his hypothetical but-for world, Apple could have an objective set of criteria to apply to rogue apps and other bad behavior. But as Your Honor may recall, he thought the question of whether or not those criteria could cover pornography and what that might be was a really tough question. Dr. Mickens testified that, and I'm quoting him now, it's important to realize that there's a spectrum because it's not just binary, whether it's prohibited or whether it's not. We either don't have third-party channels, in other words, we have what is currently the App Store, or on the other end of the spectrum, we do, and then we just have this absolute mayhem where anything goes. Then he was asked, how should it be dealt with? And by the way, Your Honor, with apologies, this is at 2709, line 19 to 2710, line 8. And Professor Mickens was then asked, and in your view, as a security expert, who decides which end of the spectrum we end up in the world where Apple does not get to centralize distribution? To which he responded, well, ultimately, I think it is the court who would decide. I think the court should consult with security experts and people who are experts in content moderation. Professor Evans simply sidestepped the issue, and he said that, well, to me, it would be, if we're talking about this case, it would be the ordinary situation in an antitrust remedy where there are ground rules typically set, in my experience, with antitrust revenues concerning preventing the party from engaging in anti-competitive behavior, and typically when remedies are established there, that's something that's thought about.
You need to slow down.
I apologize. The point being, Your Honor, that Professor Evans' testimony was, you can do whatever you want so long as it's not anti-competitive. And what that means in the context of this case begs about every question in the case. Professor Mickens, on the topic of pornography, said that if in the instance where Apple doesn't, or he's asked, where Apple doesn't want native acts of pornographic content on its devices and a third party wants to distribute it, do you have a view? Which view should prevail? And his response was, I think that's a complex policy issue. So I think that, I think the court and the two sides would have to come to some agreement on that. That's 2680, line 19 to 2681, line 10. On privacy, Dr. Mickens was asked, if Apple takes the privacy view that a user should opt in before an app is permitted to track them, that a third-party app store operator thinks no, the user should have to opt out before I stop tracking, do you have a view on which policy should prevail if Apple were required to open up iOS app distribution? His response was, it's a policy issue that once again, the court would have to decide. Dr. Evans, in response to a similar question, said, I'm not really prepared to go through a list of what they can or can't do. This isn't about prohibitions, Your Honor. This isn't about anything binary, as Professor Mickens explained. It's about the difference between where we don't have third-party channels, which is the status quo, and then when we do, and we just have this absolute mayhem where anything goes. That's Professor Mickens. And it's up to this court on an issue-by-issue, case-by-case, app-by-app, policy-by-policy basis to determine where we end up between absolute mayhem where anything goes and the current business model that has been such a success.
So the strategy, Your Honor, obviously is to scare the court. Right? The strategy here is to say, this is so complicated, this is going to be on Your Honor's desk for the next 20 years. That is not...
Well, I don't know that it'll be 20 years.
Anyway, maybe more.
That is, Your Honor, just a strategy. Let me explain in a couple of ways. Number one, it's clear that what Apple did was to take Professor Mickens, a computer science expert, and ask him a bunch of legal questions and policy questions. And I commend him for not actually answering them outside of his expertise. We can't take Professor Mickens' views as a computer scientist who is here to talk about security on how to structure a remedy as a terribly serious set of arguments. And the same thing goes for Dr. Evans, who's here to talk about the economics of the restraints at issue and not to advise the court on the legal question of how to fashion a remedy. What we're not doing here, however, is being completely at sea between the lockdown nature of the store right now and an absolute Wild West open, to use Mr. Doran's words, absolute mayhem situation. We have something. We have something, and it's called a Mac. There is a model that exists in the world that this very company that Apple has said is safe, is people can go to and download with comfort and assurance. We've seen the marketing materials, which they have used around the world, that are on their website today, at least they were the last time I checked, if they haven't changed, telling people that the Mac is a safe model for people to use. Now, I know that Mr. Federighi has...
Mr. Bornstein, let me ask you this. Epic has sued Google, and that action is pending in front of my colleague. On Google's platform, there are many stores, and yet Epic sued them anyway. One of the arguments that has been made in this case is that the iPhone should be like Android, where they have many stores. How does that address anything, given that Epic has also sued Google on the exact model that you're arguing should be the result in this case?
So there are two important things in there that are responsive to the court's question. Number one, we are not arguing that iOS should be just like Android. There is a feature of Android which we think is appropriate in the sense of getting rid of the restriction that makes iOS the only, that makes the App Store the only path for getting onto the iPhone. But that does not mean, as Apple has repeatedly said, that this is going to turn iOS into Android. And there are lots of things that Apple could continue to do in the Mac model. Second point is the reason that there is a lawsuit against Google is because Google has a set of anti-competitive restrictions of its own that it applies on the Android ecosystem in certain jurisdictions in the world, including the United States, that have similar, although not the same, anti-competitive effects by limiting in a material way the ability of developers and users to access app distribution outside of Google Play. It is not exactly the same, but there are all sorts of restrictions that are detailed in our complaint in that case that explain how Google Play is not precisely the same as the App Store, but also engages in conduct that is very similar in restricting app distribution and in-app payments.
How is it that, okay.
Your Honor?
Yeah, yes, Mr. Bourne.
First of all, I guess I would start by noting that Mr. Bornstein's primary citations to proof that the App Store would remain somehow intact is all from cross-examination questions of our witnesses asking if they knew that app review would remain in place. There certainly wasn't any foundation to what they know about what it is that Epic seeks to do here or what this court is being asked to order. They presented no witness at all on what remedy they want or why it would be workable. They've only had security experts come in to talk about the iOS operating system, and Dr. Mickens, who is a security expert, did testify on the record that on-device security would not protect against apps that encourage teenagers to commit suicide, apps targeting young children to ask whether their parents are home and where they keep the jewelry, scam apps, pirated apps, apps that are promoted for purchase via fake reviews. And that's at the trial transcript at pages 2673, line 10 to 2675, line 13. We aren't characterizing the testimony of these witnesses. We are merely quoting it. And as to Mac OS, Mr. Federighi testified in an area in which he is greatly confident and competent as to exactly why the threat model for Mac OS is different and why there are historic differences between Mac OS and iOS, and those were not refuted anywhere. Moreover, to the extent Epic now tells this court that all we need to do is treat this as if it were Mac OS, they leave out the part of their injunction where they specifically state that there can be no warnings on the App Store that you're about to go into an uncertified, unreviewed, unnotarized app, which there are on Mac OS when people try to do that. Here, they want to strip that out of the equation, making it even more bare than the Mac OS PC environment. And in terms of Your Honor's comments about turning the App Store into Android, first of all, Apple agrees with you in terms of the goal at a high level, but the evidence is, the record is, the sought injunction is to actually take the App Store far beyond where Android is right now. In paragraph 57 of Dr. Rubin's testimony, the written testimony, he described that, in fact, Android has some human review. It has various steps to find things like apps that ask or tell or encourage teenagers to commit suicide. It's not as good. It's not as successful as Apple's. It's not as effective as Apple's. But basically, what Epic wants to do is it wants this court to tell Apple to drop its arms to its side. It can continue to search for malware, but nothing more. It wants that order to be published and made known worldwide, and it wants to see if Apple can manage to hold off the attacks that hit every day, as both Mr. Federighi described. The one thing we know, and this takes us to the part of the dynamic market concept, the one thing we know is that there are many threats today, and tomorrow there will be all the threats there are today and new ones as well, and the day after and the day after. And what Epic wants to do is for Apple to drop its gloves, stand in the middle of the arena, and take what comes without any meaningful defense.
So a number of things, Your Honor. First of all, again, the strategy is very clear. It's to scare the court into thinking that a remedy here will somehow break the iPhone or otherwise cause harm to consumers and developers. It's not the case. We hold up the Mac not as what Apple must do, but as an example of a model that works that Apple could do. What we're asking the court to do is simply to prohibit certain conduct that has any competitive consequences. Apple can still do app review to its heart's content. Apple can still have an app store on the phone and encourage people to use it. If people value what Apple is providing, and I'm sure there are some who do, on the developer side and on the consumer side, those people can continue to shop at the App Store. People who would like to shop somewhere else because perhaps they do a better job than Apple does, or because they have content that Apple doesn't have but that they are interested in accessing. Those people can make a choice to go elsewhere. So there's nothing that prevents Apple from curating its store, if that word is acceptable or appropriate. There's nothing that prevents Apple from protecting its App Store consumers. That's fine. It can do that. There's nothing that stops Apple from imposing a set of guidelines on what types of apps it would like to have on its store, just like it's the grocery store who wants to stock stuff on its shelves. The problem is they are the only store in town, the only store that there is to be able to get apps out there onto the iPhone. And it's that restriction that is at issue. And consumers, once they have choice, developers, once they have choice, can make determinations about whether they value what Apple is providing or, frankly, whether Apple will do a better job because it has to compete. Because, as Mr. Cook said, we would have to differentiate ourselves in the face of competition. That's how it should work. That's what the antitrust laws are designed to encourage.
But you haven't shown me a single antitrust case where the kind of relief that you are requesting has been granted by a court and a private plaintiff comes in, who may or may not have ulterior motives. We haven't even talked about that because it's not particularly relevant. But I do think that Mr. Sweeney's testimony made clear that he would not be here today had that side deal been cut. It is a pretty significant step that courts haven't done.
So two things, Your Honor. First, just quickly as to Mr. Sweeney's testimony and the so-called side deal, there are 2 points. One is it's very clear from his email to Mr. Cook and others that he was hopeful that there would be an opportunity for this to be extended to all developers. What Mr. Sweeney had hoped to achieve if he got the deal was to make sure that that was a deal that became available for everybody. As to the substance of whether there are other cases out there that are like this one, I don't have a precise example where a court in a case involving a private party as opposed to a government party like Microsoft, and I'm reminded of AT&T as well, which was obviously a quite significant remedial order that was entered, that has had precisely the same kind of impact. But that's because we're dealing here with a pretty unique situation where we have a company of the size and scale of Apple that is engaging in conduct that has the size and scale of the conduct in which Apple is engaging. And there are...
Stop the United States government from engaging in these topics if it wants.
That's true.
Be clear, right? Epic is here because if relief is granted, they go from a multi-billion-dollar company to a significantly, maybe trillion-dollar company. Who knows? But they don't do it out of the kindness of their heart.
Why there is certainly it would be to Epic's financial advantage, as it would be to the financial advantage of every developer to cease to be out from under the yoke of monopolistic conduct. But it is, I hope, clear from the testimony and the documents that Epic and Mr. Sweeney have a commitment to this issue that has existed for many, many years. There's the email back from 2015 when Mr. Sweeney reached out to Mr. Cook, who I gather didn't remember who Mr. Sweeney was at the time, and said, this very same set of issues were bothering him. Your Honor may remember the email Mr. Sweeney sent about Vietnam and his concerns that having centralized distribution could cause problems with respect to censorship and repression. There is a long history of communications on this topic. I won't deny that it would be in the financial interest of a developer like Epic or every other developer not to be subject to any competitive consequences, but I think it would be unfair to suggest that that is the only motivation here. Epic has obviously suffered great financial harm from not being on the App Store now for 8, 9 months, whatever it's been.
Your Honor, if I may.
Yeah.
First of all, as on many other topics this morning, the only witness on whether or not this would break the iPhone is Mr. Bornstein. There's been no testimony offered by Epic on that. We do have the testimony of Mr. Federighi and Mr. Cosminka describing exactly the sort of harms to the ecosystem and the potential harms to consumers and developers which would be caused. Secondly, in terms of no other developers would be harmed and may benefit greatly, this takes us back again to the testimony of the economists, where we have here a two-sided platform which is built on the indirect network effect, where because it's an attractive platform, people come here to do business. There is no predicting what happens when the iOS environment is polluted with a variety of unpoliced different app stores from different sources, none of which we know. Third, Mr. Bornstein said that Apple can do app review
How is that perspective even accurate, given that that's what Android does, and Android survives and in fact has a larger market share than Apple?
Well, Your Honor, again, this takes us back to consumer choice. And consumers who choose to participate with Android and the things that it offers They can make that choice, and they can choose the less secure environment and have. The consumers that have elected to purchase Apple devices, we all know. It's not a mystery. It's not hidden. Mr. Cook said it under oath here the other day that Apple's brand and trade is on maintaining people's privacy and the security of their information and a secure ecosystem. And that is Apple's marketplace, and that is its niche, if you will, compared to the broader, larger Android business model. Here, the proposal, as Your Honor's already noted, is to turn iOS into something resembling more Android, but to go even further. And so those people who depend on Apple to do exactly what it's doing, who have chosen Apple because of what it does, will then be confronted without the choice that they currently have, because the iOS environment would be turned into the equivalent or perhaps even a poor imitation of Android, and that eliminates consumer choice. And finally, Your Honor, in terms of the app review to Apple's heart content, let's take just as an example the Epic Games Store. If Epic Games Store were to come into the App Store, first of all, Epic Games would have to agree to provide Apple with all of the binary code for each of the games on it. That means each developer would have to agree to provide all of the binary code for each game in the Epic Games Store. We have no relationship. Apple has no relationship with those developers. Those developers have no obligation to Apple to provide it. Then let's talk about itch.io, which has tens of thousands of different games, which is in the Epic Games Store. So now we have a store within a store within a store. And Apple has no access to the binary code for those tens of thousands of games. It has no relationship with those developers. It has no way to conduct app review on even a malware scan, Your Honor, even a malware scan, much less something looking for improper social engineering. So this would be an unsolvable problem. It would be a huge problem. And this notion that Apple can simply conduct app review on those developers who choose to send them their code, and so there's no problem here at all, is to blow right by the main issue. And in fact, Your Honor, in terms of where consumers might purchase these apps, it comes down to if, for example, Epic Games Store ceases to offer any games on the App Store, then consumers, if they want those games on iOS, are going to have to go to different untrusted stores within the iOS ecosystem. And lastly, Your Honor, the comment that Epic has been damaged by not being on the App Store since August 2008, where are we at now, 2020, it hardly bears mention, but I will anyway. They clearly could have come back onto the store. They could have litigated these claims while continuing to offer Fortnite to its customers and to other iOS platform users, and it consciously chose to disregard the interests of all of those entities, of all of those constituents, for the headline value of refusing to rejoin the store.
Okay. I will give each of you a few minutes to make closing remarks.
Sure. I might start just responding quickly to Mr. Dorn. First of all, the fact that Fortnite is not currently on the App Store is a manifestation of the principles that Mr. Sweeney and Epic have been demonstrating throughout this entire process, which is they believe these restrictions are unlawful, and they believe that the right way to go about dealing with them is to bring them to the court and not continue to abide by them. And I think that's been clear. Whatever one may think about the way in which the case has begun, it was a product and a function of the principles of not continuing to abide by restrictions that the company believes to be anti-competitive. As for the substance of the remedial points that Mr. Dorn made, first, there was a lot of discussion about a store within a store within a store. That is misguided in two respects. First, the primary remedy here is that there will be stores that are available outside of the App Store. Apple will continue to have the ability to review whatever is in the App Store to its heart's content. To the extent there is a request for a limited period of time to have stores within the App Store to deal with any competitive consequences that have accrued over time, customers will certainly be able to know when they are downloading something from another store as compared to when they are downloading something from Apple. Apple has more than enough ability to make sure that consumers know who they're getting something from and what they're getting. And those people who value what Apple offers can choose to buy from Apple and can continue to do that. As for the other security points, it's first clear that the issue that has arisen around having the App Store be the only store was not a decision that was made entirely based on security, but rather based on policy. And that goes back to PX 877, which was that white paper that was put together by the security experts at Apple back when this decision was being made. And they made clear that this was a policy decision as to whether Apple should distribute outside the store. And Mr. Federighi admitted on cross-examination that there are other ways, using his words, to turn off the spigot of apps that have gone bad. And that's, for example, through code signing. That's at 3452 of the transcript. But to step back more broadly, Your Honor, as I said, the theory here seems to be to make the court concerned about stepping too far to deal with the anti-competitive consequences of the conduct that are at issue. And I acknowledge, Epic acknowledges, that this is an important case, that there is an important set of conduct, and that a remedy that would be entered of the sort that Epic has requested would be important and significant. But that is because the issue affects such a large number of consumers, such a large number of developers, and has persisted for such a long period of time. And remedying that conduct is, of necessity, a more robust endeavor and exercise than your typical injunctive relief, because the conduct and the harm is more robust than the court would typically face.
Your Honor, the theory here, or the strategy here, is to make the court aware of what Epic is asking. And if that is scary for Apple's iOS customers and for Apple's developer community and for Apple and for this court, that is simply a consequence of what it is Epic is asking for. Even in this last narrative, we heard things that have never been said before and are in no filing with this court, such as a comment about it's not that there's no ability to look at stores within the stores. If it's necessary to have stores within the App Store for a limited time while the anti-competitive effects are worked out, I don't know where that's coming from, and I don't know what it's referring to. And then there's the statement that Apple certainly has the resources to tell people if they will be using things from an untrusted source. But their injunction specifically demands that there be no attempt to discourage the use of any of these other apps. Epic is talking out of both sides of its mouth on this, when the impact and the results and the way this will play out in practicality are plain and are simple. Dr. Rubin testified that the vast majority, more than 90% of app attacks are based on social engineering. And the only thing that Epic is willing to permit Apple to do for any apps that are not submitted to the App Store is to do some sort, they don't describe what, of malware review. That does nothing for these social engineering issues, as admitted by Professor Mickens. And that is the iceberg under the water, not the tip of it, which in Apple's case, because of its excellence, is malware. And finally, Your Honor, on this topic, I would just say that the law protects technological incompatibility as pro-competitive. That is how consumers are given a choice. Your Honor, I commend the court to Foremost Pro, which was the basis of the jury instruction back in the iPod case. And that case follows Trinco and its progeny. And, Your Honor, I would also point out that Qualcomm was decided in the first instance on the absence of a duty to deal. Your Honor, Apple's business model was developed long before it had anything that anyone claims as market power. It has served its customers and developers well, and Epic is now attempting to pro hoc dismantle that without any clear requests of the court and without any clear testimony or guidance as to what the impact of that attack would be.
Your Honor, if I could respond to one point, which is the accusation that this is a new request. I'm not sure where that comes from. I'll show you our January 22 remedy filing, paragraph 4, specifically says that to remedy Apple's past misconduct and its anti-competitive effects and to restore competition, Epic is requesting that the court grant time-limited relief for a period of 3 years to have apps on the App Store. Precisely the point that I made earlier. This is by no means a new request. Also, what appears on the slide that's been up on the screen for a little while. But ultimately, what I continue to hear as the theme from Apple is we're doing a really good job, Your Honor. Please let us continue to do a really good job. Even if you're not saying, even if we're a monopolist, I realize that, but this is the undertone. We're a good guy. We're the benevolent overlord of this ecosystem. Let us continue to do it without competition because it's worked out okay so far. That is not a defense under the antitrust laws, where competition is what's supposed to drive excellence, not our just trusting that Apple will be excellent on its own.
Last comment, Your Honor.
No, it's just, you don't have a benevolent overlord and anti-competitive effects. They're not really benevolent if you have anti-competitive effects on them.
Yeah. Your Honor, that's actually not so. I disagree with that. You have them pretending to be a benevolent overlord and saying, we don't think anybody should compete. We're trying to do a good job. But the point is you have to compare. You have to decide whether what they're doing is what it would be in the face of competition. And they're saying, trust us, we're doing as well as we otherwise would.
You know, all I wanted to say on that point was I thank counsel for the clarification. I had actually thought 3 years was for all relief sought. Turns out it's only time limited in one instance, and the rest is without any time limitation at all.
Mr. Goldstein, it's your burden. You get the last word.
Right. Your Honor, I'll just use as the last word the opportunity to thank the court for the time that you've given us in hearing this case. We know the tremendous amount of work that Your Honor has done to hear it and to give it the consideration that we think it deserves. And we really just want to express our appreciation for that. So thank you.
And on this point, Mr. Bornstein and I can agree. And both the court, its staff, its clerks, we appreciate all of the effort that the court's put into this matter and all the effort that we know the court has yet to go.
Well, on that front, and I've said this now, I think a couple of times, and it doesn't hurt to say it again. I did and do find that the lawyers in this action on both sides have really been a terrific example of what lawyering is and can be. Having been a partner at a big firm, I know that that's not always the case, and it's unfortunate. In this court, actually, it was an antitrust case. When I first took on the lithium-ion battery MDL, I'd come over from the state court, and I had a set of professional rules of conduct that I used, and I was told when my arm was twisted to take that MDL because I thought it would never be given to a new federal judge. I told the lawyers that I expected that, and I asked them to write a professional set of rules and guidelines that they as lawyers could abide by. And they did. And those guidelines became the Northern District's guidelines. So it's important to me. I think it's important to the bar. And we can be, and you can be, fierce advocates and yet still professional. And that's important if you're all going to survive long careers. I know, I think I have a reputation for being a little tough, but it's all with the best intent to get to the right answer for folks and for litigants. There is a lot of material. So I made a joke the other day about August 13th, which was the date of the hot fix. Not everybody got the joke. So I am not promising to have this by August 13th. But I am going to try, as I said to you, I want to try to get to this while the memories of the testimony is fresh and while your arguments are fresh. But we do have thousands and thousands of pages to review. I believe the staff told me we had 4,500 pages of testimony. And so there's quite a bit of work still to do. So you will receive my my decision in writing. What I tell my jurors, and perhaps for those folks who are listening who are not lawyers, but I do tell my jurors at the beginning of a trial, opening arguments, the lawyers tell you what the cover of a puzzle looks like. I like puzzles. Physical puzzles more. And during the course of the trial, I tell them, I say, now pretend here we are. We haven't taken any evidence. We have an empty box. That's it. It's empty. The lawyers can tell you what they think the evidence is going to show, but we've heard nothing. And then during the course of the trial, when I have to remind them not to go do their investigation or find out their things on their own, I tell them, our box is getting full with puzzle pieces. And by the end of the trial, say, okay, that's it. No more pieces. There are no more pieces in that box. You may have wanted other pieces. You may think pieces are irrelevant, but that's it. And then during closing argument, the lawyers explain what they still think the cover of the box is. But it's up to the jury, and in this case, it's up to the court to figure out how all those pieces come together and what the cover of that box actually looks like based upon the evidence. So that's, for those listening who have not been in trials, that's what we're doing. We're taking all of that evidence, all of that testimony, all of those documents, and putting it together in a way that seems to make sense in the context of the law. That's what we do. So it will take me a while to do that. But I do appreciate everything and of course your support of the court and your support of the staff. It's been tiring, but a real pleasure. And I hope to see you all at some other point as all our careers continue to progress. Okay, you're adjourned.
I hate to raise a mundane issue like 3 exhibits, because I'd rather leave with that warm glow. But I believe I'm speaking for both parties on 3 points. BX 5447 was referenced when first admitted as BX 5547, so that needs to be corrected. 5547 is not in evidence. 5447 is.
Okay.
BX 3734 is also admitted, and I don't believe it's currently on the list. That was admitted by stipulation of docket 635 of May 11.
Okay.
And then BX 5441 was a spreadsheet that was used with Mr. Malachowski, but it was referenced as in evidence, but none of us have a record of it actually being placed into evidence, so that should be removed from the exhibit list.
Okay, so 5447 is out, 5441 is out, 5547 is in, and 3734 is in. I understand also I'm meeting with some of the newer lawyers to the profession tomorrow. There was a request, I think, but I just asked as Ms. Forrest if you and Mr. Dorn will confer on that last issue. Whatever is fine with you all is fine with me. And I'll see them here in the courtroom tomorrow morning.
Thank you again for that, Your Honor.
Okay. All right. Safe travels.
Thank you.
The recording has stopped.
I think this might be the end of everything. One shot, two lost, and a wedding ring. Speak now, hold your peace, I say a thing. Wish I would've, cause baby, I'm a fuck now. Starting to think that this is only the beginning. My brain is going too fast, a mile a minute. Love grenade in my hand, somehow I managed to pin it. She don't like her friends, yeah, she's just trying to fit in. Run, baby, I think they might get a little dicey. And I don't really care about your friends and if they like me. I just said I'm fucked up and I think that he's right. Cause everyone got
Your conference is ending now. As requested by the host, please hang up.
On your shoulder, doesn't matter where I'll I keep my friends in a fold, it doesn't matter we're over. And the world's on fire, at least that's what I told her. And I'm sorry for the way, I'm just mulling it over. It's a pity how like everything turned out. It was going so well, till you open your damn mouth. And you first saw so bad, and like that's without a doubt. And there's still one little thing that my brain can figure out. How you lie to me so constantly, and I don't really care. My brain like the bottom of me, cause you were never there. So I'll be out your head. Mama always told me life is never ever fair. Put my phone on D&D cause I don't want nobody to call. I wanna see how you text, I don't wanna see you at all. Got a B&B 2 miles away from the mall. Nobody getting it cause I don't care about y'all. Put my phone on D&D cause I don't want nobody to call. I wanna see how you text, I don't wanna see you at all.
up for a good time. Corona, get that good vibe. Drinking till the sunrise, just like we used to do. Mexico, let's go there. Yeah, sex is slow, I don't care where we go as long as I'm there with you, just like we used to do. Still tired like your friends, what we used to do. Yeah. I say the feeling's mutual. Distance between us dissolves when I fly over. Pull up, shotgun, sitting wide open. Hop in, tell me how your life been. Used to talk every day till the night's end. Been a year now, I'ma need the whole school. You thriving, update me on them goals too. Yeah, I could listen to you forever. Filling up a few of them strong, never let them take us anywhere they plan to. Don't jump the gun, but when we sippin' something, you already know what's up. Lean back, I'll take you where we used to go. We both familiar on what the future holds. Bottoms up for the time that we wasted. Later we got reacquainted. Pour up for a good time. Corona, get that good vibe. Drinking till the sunrise, just like we used to do. Mexico, let's go there. Yeah, sex is slow, I don't care where we go as long as I'm there with you, just like we used to do. You work hard, you need a vacation. I'll take your lifestyle, rearrange it. Put you on a plane with a destination, a white sand. All this funded off a mic stand. My right hand, I'm catering to your life. From the room, see the waves at the shoreline. Skin tan, you blended with the locals. Burn bread on you, something we could toast to. I'll promote you, show you to the universe. Got a couple on reserve, but you was first. Yeah, always have, always will be. You're the only one who gotta know the real me. So lean back, I'll take you where we used to go. From the clouds, you can view the coast. I feel the same for you, I don't even gotta say shit. Later we got reacquainted. Pour up for a good time. Corona, get that good vibe. Drinking till the sunrise, just like we used to do. Mexico, let's go there. Yeah, sex is slow, I don't care where we go as long as I'm there with you, just like we used to do. Usually I put it down and withdraw. You always getting a round of applause. Standing ovation, give me an encore. Yeah, I need an encore. Tell me that you coming home with me. Love it when you fitting close to me. Showing you how it's supposed to be. I know you know it's me. Pour up for a good time. Corona, get that good vibe. Drinking till the sunrise, just like we used to do. Mexico, let's go there. Yeah, sex is slow, I don't care where we go as long as I'm there with you, just like we used to do.
Dang girl, you move like smoke through the crowd and the neon. Heavy guy tryna play it cool, but you're turning the heat on. Back where I come from, nights are hotter than the days. You can shoot me down, but I'm just saying, DJ's finally playing something we could dance to. Take a midnight chance to press your body right up to mine. Throw back your head and close your eyes. Maybe move my hands to your hips or any way you want them to. Feel the backbeat bumping, not still young and we got something, yeah. Something we could dance to. Yeah, 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 yeah. Something we could dance to. Yeah, 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 yeah.
I know I came with my friends. No, I don't wanna come off rude, but baby, it's obvious that I got a thing for you. Come on, boy, move your feet. Oh, what you got to lose? I won't shoot you down. I'm just saying, DJ's finally playing
something we could dance to. Take a midnight chance to press your body right up to mine. Throw back your head and close your eyes. Maybe move my hands to your hips or any way you want them to. Feel the backbeat bumping, not still young and we got something, yeah. Something we could dance to. Yeah, 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 yeah. Something we could dance to. Yeah, 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 yeah.
Look, firm grip when you shake that. All about my business, making good use of what your mama done get. Looks, tan, you got it, I need you. Good blend of Camilla and Shakira. Full-time betting, never part-time. Lose memory when you back it up like a hard drive. Past flames couldn't set the room on fire. You look amazing. Got them all staring when they playing.
Something we could dance to. Take a midnight chance to. Press your body right up to mine. Throw back your head and close your eyes. Maybe move my hands to your hips or any way you want them to. Feel the backbeat bumping. Not still young and we got something here. Something we could dance to. Yeah, 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 yeah. Something we could dance to. Yeah, 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 yeah. Something we could dance to. Yeah, 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 yeah. Something we could dance to. Yeah, 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 yeah.
Turn their backs in the past, now they wanna come back. Too bad I'm not practicing forgiveness. Realize that they fucked up, now they see me get some. Can't eat while you standing in my kitchen. Yeah, I remember when you talked down, hands out, thinking that you getting some odds now. If you weren't there for the grass rules, I can't let you in, I'm sorry to break the band.
Okay, they still up in that beta stage. This should go and wake them up. 200 for a saving grace. I feel I wasn't paid enough. Predicting what I complain about when Ollie catch a major buzz. Hundreds too freshly pressed. Watch out for the paper cuts. The dude working, the tour coming. I'm poured up. The new burden is getting room service in foreign tongue. Boarding a Bombardier to fly to where I'm born from. And when I land a bad Insta influencers swarm us. Women they loving the dude.
Welcome to A. To join the conference, as the host has not yet arrived, please stand by.
I can't fall up in the thought. I fuck them, it's something to do. They quick to have the marriage talk. And no one can fit in my shoes, so they watch it where I walk, but can't mimic it. Cramp sprinting the caste system. I was born for it. 4th and inches, I'm going for it. I can't wait to trade for the skate for foreign plates. 4 mortgages, all of them out in Florida. There's gotta be more to this. Can't bring you if you ain't on the list. Turn their backs in the past, now they wanna come back. Too bad I'm not practicing forgiveness. Realize that they fucked up, now they see me get some. Can't eat while you standing in my kitchen. Yeah, I remember when you talked down, hands out, thinking that you getting some odds now. If you weren't there for the grass rules, I can't let you in, I'm sorry to break the bad. When I get a mansion up in the canyons, I'ma go pass this shit to my dad. I'm putting my mama on the yacht, putting Sebastian up in the fastest with the Jag back to Jacksonville, get Stephanie Cabal. Cause when I'm on and I don't give a fuck, I'll definitely need it all. Not just talking, I got a knack for making it come to fruition. Came in thinking you get famous, boy, I've come to do business. Seen a ton of all of it happen, they only fuck if you winning. Pussy or push me into distraction, can't keep none of you winning. Don't be turning on them read receipts, hoping that you teasing me. Jokes on you, bitch, you're not the only girl that's seeing me. You get through with your features, opportunity seeker. You think you get smooth, talk me hard, truthfully speechless. Cause I work for this, I stayed the way. Paid the lane and stayed the same. Invest in me if you want me to take you in and break the bank. And to all you broke hoes and my past friends who chose to shut the door on me, I'll never let you back in. Turn their backs in the past, now they wanna come back. Too bad I'm not practicing forgiveness. Realize that they fucked up, now they see me get some. Can't eat while you standing in my kitchen. Yeah, I remember when you talked down, hands out, thinking that you getting some odds now. If you weren't there for the grass rules, I can't let you in, I'm sorry to break the bad news.
I lost myself that night, I threw it all away. Those are the things I've hated. Then I went and caved in. I'm a mess right now. My heart is in two places, half is back at home. The other's off and racing. I've been running and running and running and running away. I know they'll catch me running and running and running two opposite ways. I can't let my past catch me now. Me now. I can't let my past drag me down. Me down. I lost myself that night. I threw it all away. Recall my mother's words, but it was far too late. I feel the burden now, it's weighing down my soul, and I can't catch my breath, cause these demons follow. I've been running and running and running and running away. I know they'll catch me running and running and running two opposite ways. I can't let my past catch me now. Me now. I can't let my past drag me down. Me down. I can't let my past catch me now. Me now. I can't let my past drag me down. Me down. Swear I've changed, but you don't care that I'm not the same. You'll always hold me. I swear I've changed, but you don't care that I'm not the same. I can't let my past catch me now. Me now. I can't let my past drag me down. Me down. I can't let my past catch me now. Me now. I can't let my past drag me down. Me down.
Fake, no, this ain't no fiction. Love, no quotation. Sick of this rotation. Dropping my location. Never gotta go chasing. Just kill your base. I love you like you love me. You wonder if it was something. Same way I whisper sweet nothing.